Oyez, oyez, oyez. All persons having business before the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3019. United States of America versus David Floyd, appellant. Ms. Amato for the appellant, Ms. Kelly for the appellate.
Morning, Ms. Amato.
Good morning. Good morning, Your Honors. May it please the court. On behalf of Mr. Floyd, we assert that his trial counsel at the district court level was ineffective during the plea negotiation phase by agreeing to an enhancement, which was part of ultimately the plea agreement, which was signed and agreed to. He was ineffective in the negotiation, in informing the client, the defendant, Mr. Floyd at that time, that this was an appropriate plea agreement. And Mr. Floyd in this case was charged, as the court is aware, with one count of drug conspiracy. But as part of the guideline calculations, as part of the plea agreement, the parties agreed to a two-level upward adjustment under 2D1.1B1, otherwise known as the gun enhancement. We assert—
Did the parties agree to that? I mean, Mr. Floyd's counsel reserved the right to argue that it was not applicable, right?
Did not. The parties agreed that the application of the guidelines would start out with a drug offense level, which they agreed to, and then also to the two-level points upward for the 2D1.1B enhancement. So this was not a plea where the parties agreed to disagree. This was a plea where both parties agreed to that. And so therefore, if later on defense counsel tried to object to it, it would have been a breach of the plea. And so therein lies the issue and the ineffectiveness in agreeing straight out in the plea agreement that the application applied, the enhancement applied. And submit that under the Strickland prong, the first prong, that it was that trial counsel's conduct fell below an objective standard of reasonableness.
How are we to interpret the reservation of allocution section of the plea agreement that said that the parties could address the correctness of any guidelines calculation by the pre-sentence report writer or the court?
Right. And
even if those calculations differed from the estimated guidelines range in the plea agreement.
So that's a different scenario from what they could object to relative to the plea agreement. The plea agreement, the parties have agreed that this is the framework. Drug offense level plus the 2 points for the enhancement. Now, if the pre-sentence report writer came back with some other enhancements, then the parties could have disagreed and objected to those additional enhancements. But as to the enhancement of the 2D1.1B1, which was part of the plea agreement, the defense could not at that point object because it was part of the plea agreement. So the pre-sentence report, if they came up with additional enhancements, that was something the defense reserved the right to object to. But that's not what happened here. It wasn't that the pre-sentence report just came up with an additional enhancement. The enhancement was part of the plea agreement. And so that's the issue here, because that enhancement did not apply.
So the commentary for the guidelines in lots of cases in this and other courts talk about the fact that guns and drugs go together. And that's in fact the reason why the enhancement is in the guidelines. So it seems to me that for you to prevail on your deficiency argument, you have to show that in this case, it was completely unreasonable for his lawyer to agree that drugs and guns could go together in this case.
Excuse me. This circuit has found that there needs to be a nexus between the guns and the drugs. In the case of U.S. versus Miller, 890 F. 3rd 317, D.C. Circuit case of 2019. And here we have no nexus between the guns and the drug conspiracy. What we have here, the statement of facts basically puts out what the facts are in this case. On January 19th, we have Mr. Floyd and his brother traveling from the United States down to St. Thomas. The next day, January 20th of 2021, Mr. Floyd and his brother go to the post office in St. Thomas, and they seek to mail 2 packages of the cocaine, the drugs, from St. Thomas. The packages are intercepted by law enforcement. Ultimately, there's a controlled delivery of these drugs on January 29th, 2021 to an address in Bladensburg Road, DC. The brother of Mr. Floyd is present. He receives the drugs. He's arrested. A month and a half later, on March 12th, is when Mr. Floyd then seeks to send the 2 weapons, which are part of this 2D 1.1B1 enhancement, but not back to St. Thomas. He's trying to send them to St. Martin. So you've got this 1.5 month time period, but regardless from when the drugs were being sent from St. Thomas to the United States, but even if it was the next day, there's no nexus here in the statement of facts that were presented to the court or at any point in any of the arguments in the plea hearing or the transcript that tied those guns that were Mr. Floyd tried to send to St. Martin to the drugs. The plea paperwork and the statement of facts then jumps to October 7th, some 6-7 months later, in which a wiretap is requested by law enforcement of Mr. Floyd's phone for a 30-day period. Based on that, it's determined that Mr. Floyd is still selling drugs. Then there's a search warrant on November 10th, and then he's arrested. But those guns that he tries to ship on March 12th, I mean, there's no connection whatsoever. And
But there's guns that are found when they arrest him, right? At his residence or a residence that he's connected to.
There is a gun that's found at the residence that he's connected to. He's not arrested there. So the question is whether there's constructive possession. What's interesting though is
and the guns are next to scales and a bunch of other drug paraphernalia.
Correct. But what's interesting about that gun and this plea is the government was very specific in their statement of facts as to what gun applied to the 2D 1.1B enhancement. And although they mention in the section, which is section number 1 for the drug conspiracy, that weapon that's found at that other location, they never mention it in the section for the 2D 1.1B1. And I have to think, well, why is that? And I believe that
Is there a requirement that some sort of specificity requirement that they mention a particular gun as a basis for that enhancement in either in the plea agreement or indictment or?
Yes, Your Honor, I believe there should be, because how can the court then ascertain whether or not the enhancement applies?
I understand you say there should be, but what authority is there that there is such a requirement?
Well, I believe the guidelines require there to be, I mean, for this to come into play, how would one be able to bring it into play if one just?
I mean, that sentencing, you know, as you're well aware, the government brings up all sorts of things, some things that aren't charged, some things that aren't even in the statement of offense at all, right? And they can be used to, you know, as part of the guidelines calculation.
Certainly.
We've never, at least I'm not aware of a case where we've said that you can't do that because that wasn't set forth at the time of the plea.
Certainly. But I would say in this particular case, because they were so specific as to which gun applied, that the government at the trial level didn't feel that they had enough evidence as well to tie that other gun in that residence. Although they indicate that Mr. Floyd was connected to that residence, they don't indicate that his name was on the lease, which would mean that there were other people connected to that residence. There's nothing in the plea agreement in which it's definitive that Mr. Floyd agreed that he possessed that weapon. So I believe the government had several hurdles. There was no DNA evidence in the record that tied him to that gun. There was no fingerprint evidence that tied him to that gun. So I believe in the record, the government felt that they had an issue being able to put that forth as an enhancement, and therefore they never brought it forth to argue that that would have been another enhancement that they could have presented in support.
He gave up a litigable issue on the enhancement. In return for that, he got all sorts of benefits. They didn't prosecute on the ghost gun. They didn't seek the mandatory minimum of 10 years. They didn't prosecute him for being a felon in possession. Sounds like a pretty good deal.
Well, I mean, he was charged in one count. For the government to have brought additional counts that would have required more work. And for the government might have been just as happy to try to negotiate this so they wouldn't have to do that additional work.
All right, we'll give you some time on rebuttal.
Thank you.
Morning, Your
Ms.
Honors.
Kelly.
May it please the court, Catherine Kelly on behalf of the United States. Your Honor, I would like to point out, just in addition to the points the court had made, linking the gun as a proper reason for the gun enhancement in this case, there was also, in this situation, Mr. Floyd has shown no prejudice that would show that his counsel was ineffective. As the court had just pointed out, the plea agreement freed him from numerous other convictions or potential convictions. He had the potential, without the plea agreement, to be sentenced to a mandatory minimum of 10 years rather than the mandatory minimum of 5 years that was placed in the plea agreement terms. He received 3 points, excuse me, for the early acceptance of responsibility by pleading guilty. It freed him also from prosecution separately under 922G for the gun he used at the Maryland firing range during the conspiracy. The guns he mailed to St. Martin as he possessed them in the District of Columbia while he was mailing them on
Why
March
didn't the
12th.
government indict those in the first place if this was such a big deal? I mean, he didn't have to negotiate anything away with respect to that because the government didn't indict it in the first place.
The government, in regard to the guns specifically sent to St. Martin,
Yeah.
Your Honor? Well, the government certainly could have charged that as a separate 922G offense. As during the plea bargaining, they chose not to, and they also could have charged the Glock that was found in the W Street apartment.
I understand that, but well, there's two aspects of this. The first aspect is that you say that there's no prejudice because all of those things could have been charged, but the government could have charged those all along and they never did. The case was pending for over a year before the plea agreement was reached, if I remember correctly.
It had been pending, Your Honor, but my understanding of the plea negotiations is that those were also ongoing over the course of time. And I believe he had 3 attorneys. So this was something that was ongoing, but there is no reason why the government couldn't have charged those. And particularly in regard to what defense counsel said about the gun at the W Street apartment, there are strong links of Mr. Floyd to that apartment. Number one, he rented that apartment. He also visited it almost daily before going to his mother's house where he dealt and distributed drugs. Mr. Floyd's passport was found there along with, I believe, a digital scale, $28,500, and the Glock 9mm gun, which was loaded. So there are very strong ties to the W Street apartment and Mr. Floyd and drug dealing. That's at pages 64 and 65 of the public record in this case.
Let me ask you about how we're supposed to view prejudice. Why isn't the prejudice prism the prism of sentencing as opposed to what he could have been charged with had the plea agreement not gone forward? mean, his claim is that this one specific sentencing enhancement shouldn't have been agreed to. And if it hadn't have been, then he would have started with a different guidelines range, which presumptively would have benefited him because that would be, kind of the starting point, so to speak, in sentencing. So why isn't that the correct prism to look at the prejudice?
Because when you're looking at a defendant who has claimed that the prejudice is arising from his attorney's allegedly deficient performance during plea negotiations, the remedy for any potential deficient performance by his counsel is not simply just to take away a plea provision, or rather a sentencing provision that he doesn't like. You don't take away a term of the plea agreement. You have to look at the prejudice standard that applies in that situation, which is whether or not, but for counsel's allegedly deficient performance, the defendant would have, there's a reasonable probability that Mr. Floyd would not have pleaded guilty and would have insisted on going to trial. And Mr. Floyd has not met that burden here at all. In fact, he has not asserted, in fact, has been insistent that he wanted to enter his plea agreement. And in fact, he wanted to keep his plea agreement, even when he was complaining about the gun enhancement at the hearing right before his sentencing. So for those reasons, he has not ever met the standard that actually applies to alleged deficiency during plea negotiations. And again, going to the prejudice, the court has been clear in United States versus Scanlon that neither this court nor the district court can modify or amend a plea agreement. So what Mr. Floyd is really asking for here is for this court to remove the gun enhancement sentencing provision that he now doesn't like in his plea agreement. That's just not a possibility. That remedy is just simply inappropriate. And again, when you look at the prejudice, the facts don't support prejudice, even if you used Mr. Floyd's inaccurate prejudice analysis.
So let me ask you this. Suppose a defense lawyer agrees in a plea agreement to a sentencing enhancement that is, when we look at it now, was just patently not applicable. Assume that fact for the hypothetical. Are you saying that on review, the question is whether, had the lawyer properly advised the defendant and not agreed to that, the question is whether the defendant had the defendant known that, would have gone to trial?
Yes, we believe that is the standard.
So why is that the standard in a situation where a reasonably competent lawyer would never have agreed to that enhancement because it doesn't apply? We would find that to be deficient performance. And wouldn't we say, well, we don't know, we can't say that there was no prejudice because the government might agree to a plea agreement without this illegal enhancement, even if the defendant didn't really want to go to trial. The government didn't want to go to trial either. That's why they entered into a plea agreement.
Well, I think another way that prejudice standard has been put is that the remedy for an unknowing and involuntary plea agreement would be to permit the defendant to withdraw his guilty plea and return the parties to the negotiating table. So stated that way, the point really is to unwind the plea agreement if there's a problem with the plea agreement. That doesn't necessarily mean that the government then absolutely has to take them to trial. If there is a way to negotiate another plea agreement that's favorable to both sides, the parties are still available to do that.
And that's precisely my point. So why then isn't that really the prism that we're looking at, and not necessarily that there has to be a showing that the defendant intended to or would go to trial if the plea agreement were unwound?
I think that either wording can be used. I believe I've seen that in different cases, that the wording can be used in that regard as well. There is a point, though, that we pointed out in the Lafleur versus Cooper cases, that the remedy has to neutralize the taint of whatever constitutional violation is at play, but it can't grant a windfall to the defendant. And what the defendant is asking for here is just to simply have this court remove what he now sees as an objectionable part of his plea agreement, and then continue on to sentencing as if that provision didn't become part of the plea agreement in the first place. And that's the part that we think is inappropriate. What could have been done in this case is that the government could have substituted the gun found at W Street for the guns mailed to St. Martin if that became too objectionable in future plea negotiations. Because it sounds like Mr. Floyd, from what he told the court just before his sentencing hearing, is he did want to keep the plea agreement. But our point is you can't just simply excise part of the plea agreement that you don't like, because that is a windfall to the defendant. All the terms of the plea agreement have to be renegotiated. It can't just be a matter of picking and choosing at the time of sentencing which provisions of the plea agreement that you fairly negotiated. Mind you, with counsel that the district court found to be effective and found to have well represented Mr. Floyd in this case. So particularly here where the district court has heard from Mr. Floyd and his counsel, we think it would be particularly inappropriate to simply excise that term of the plea agreement that he now disagrees with. So.
All right, thank you.
Thank you, Your Honor.
Ms. Amato, we'll give you 2 minutes for rebuttal.
Thank you. And I wanted to point out that this isn't a case where Mr. Floyd is trying to receive some type of a windfall. During the plea hearing, he actually brought up to the court when the parties put on the record what the plea agreement was. And the parties put on the record the drug offense as well as the 2D 1.1B1 enhancement. And when he was asked about those guidelines, he lodged an objection and said he didn't agree with those, that they were incorrect. And we know that he didn't really understand or wasn't given full clarity relative to the guidelines, because then later on in the plea hearing, the judge asked him if he had spoken with his counsel about sentencing and how the sentencing worked, and he said no, and then a recess was taken. Unfortunately, the issue wasn't cured at that point because the judge didn't come back then and ask him specifically, have your issues with the guideline points been resolved? And also to clarify what those issues were. So Mr. Floyd sought at that point to lodge an objection to the guidelines. Basically, it didn't go anywhere. It wasn't cured. And then at sentencing, after he then had the time further to review the pre-sentence report and see most definitely that those guidelines were there and the enhancement was there, that then he brought up the whole ineffective assistance claim and went from there. So
Suppose we were to agree with you, what is the remedy you think that we should give you or your client?
well, I mean, of course, Mr. Floyd is asking for resentencing without the enhancement.
And what authority is there for that remedy?
Well, looking at the U.S. versus Thomas case before this circuit, in which this court did specifically find that that if a defendant can show a reasonable probability that the end result of the criminal process would have been more favorable by reason of a plea to a lesser charge or a sentence of less prison time, that he is satisfied that prejudicial prong. I mean, we know that in terms of the plea, he didn't want to plead with those 2 points. We don't have on the record, though, whether if it's a question of either this plea or going to trial, which he would have chosen. That's not in the record. We just know that he was seeking a plea without these 2 points. And so his remedy ultimately is to be
That
resentenced without.
Gives you all of the benefits of your bargain with none of the corresponding burdens.
Well, again, I mean, he had brought the issue up to the court during the plea hearing. It wasn't cured. And I guess that's where we're at this point.
Thank you.
Thank you.
Ms. Amato, you were appointed by the court to represent Mr. Floyd in this case, and the court thanks you for your assistance.
Thank you, Your Honors.
The case is submitted.
Case number 25-5109. Associated Press versus Taylor Budowich in his official capacity as White House Deputy Chief of Staff et al. Appellants. Mr. Roth for the appellants, Mr. Tobin for the appellants.
Good morning, Mr. Roth.
Good morning. May it please the court, Yaakov Roth on behalf of defendants. Your Honors, the issues presented here are largely the same as the issues that were addressed by the state panel a few months ago, and both the majority and the dissent on the state panel laid out pretty comprehensively the conflicting approaches to how to apply the First Amendment in this unique context. We obviously think the majority got it right, and so we would ask this court to now vacate the injunction for the same reasons as the court previously stayed the injunction.
You think the state panel got it entirely right? I assume you're not giving up on the East Room.
Not giving up on the East Room, but I think the state panel's analysis and sort of analytical approach to the issue was correct. I think the way that shakes out for the East Room, we can talk about, but sort of the overall approach that the court took to form analysis and the other aspects of the doctrine, we think the court got it right.
Do you think that this was a close question?
I think it's in some ways a novel question because most of the forum cases in the law have really dealt with the difference between a public forum and a non-public forum. And there are very few cases that address the distinction between a non-public forum and things that are not a forum at all. So I think it was sort of a novel question in that sense. But I think the way the court approached that distinction was the right way to do it.
Ms. Roth, so on the East Room, in your briefing, you make almost no specific arguments about the East Room, and the East Room wasn't addressed by the state panel. And in many ways, the East Room is quite different from the Oval Office and Air Force One because it's used for many different purposes, sometimes with the president, sometimes without the president. There are all kinds of events that happen in the East Room. So I was actually wondering if you were just, maybe not forfeiting exactly, but not really pressing the East Room argument. Maybe the East Room is more like the Brady press room.
Your Honor, my colleague who argued the stay, I think, said it was in between. And I think he's right that it is in between. Now, it hasn't been the focus of the briefing frankly, by either side. The case has largely been focused, as it was in the district court, on the Oval Office and the comparable spaces. I think the similarities between the East Room and those spaces are essentially two. Number one, we don't have indication in the record that the East Room has been set aside for private speech, much like the Oval Office. We don't have that. Whereas we do have indication that the Brady briefing room and the press area as a whole was designated specifically for the press to do their work, including their own speech. So I think there's a difference between, I think in that respect, the East Room is similar to the other spaces.
The fact, though, that the East Room really is used for myriad purposes. I mean, the Brady press room is used largely in a similar way for press briefings and questions with members of the administration. I mean, the East Room, I mean, if we were to reach the East Room, would we have to remand for further factual finding? I think it's very hard to have a single rule for the East Room, given its myriad purposes, which sometimes involve the president and sometimes do not. As my understanding, based on my experience.
Your Honor, I think that's a fair comment. There is just not as much in the record on the way the East Room is generally used. The focus, again, has been much more on the other spaces. Now, I do think the AP could have, in their brief, said, even if you don't agree with us on the Oval Office, we still win on the East Room. And I don't think they haven't litigated that way either. So I think neither side has really tried to break it apart.
Take the East Room out of this litigation?
Well, I do think that the most important aspects of this litigation do relate to the Oval Office and the spaces that are like the Oval Office.
Can I ask you about standard of review, which is abuse of discretion, right? Are you familiar with Ashcroft versus ACLU and Gordon versus Holder? Ashcroft versus ACLU is a Supreme Court case from around, I think it's around 2012. No, earlier, 2004. Gordon v. Holder is from our court in 2013. But they're both cases involving review of preliminary injunctions entered against the government where there were constitutional claims, due process, or First Amendment claims. In the Supreme Court in Ashcroft v. ACLU said that in applying the abuse of discretion standard of review, if the district courts, if it's a close question and there's a reasonable argument that the district court got it right, you leave it in place and then you decide the question ultimately after there's been a full record and if a permanent injunction is entered. But what you don't do at the preliminary injunction review stage is decide those close questions where the record hasn't been fully developed. And we held the same in Gordon v. Holder. So why isn't this that case?
So, Your Honor, I'm not familiar with the cases, and I don't think the AP has made that argument here. At least I don't remember that from the briefing.
We have to get the standard of review correct.
For sure. And I think
we have to follow the Supreme Court precedent, don't we?
You do. The parties, of course, make their arguments and the court responds to those arguments. I think
so
ordinarily.
If the party argues the incorrect standard of review, we apply that standard of review.
And if the parties agree on it, sometimes the court will look past the issue and say the parties agree this is the standard. I think everyone agrees the standard is abuse of discretion, but abuse of discretion includes de novo review on issues of law. And I think the dispositive issues here are issues of law. How do we classify the Oval Office for purposes of form analysis? And more generally, is this the type of context where viewpoint neutrality is required? Or is this like the various other contexts where we allow the government to engage in viewpoint discrimination? That's the legal question that I think controls the case. I think review on that question would be de novo. And again, we think the state panel got that question right.
Isn't it a close question? I mean, there was a dissent. The stay level, there were two judges on whether we should review that en banc who indicated that they believed that the state panel may not have gotten it right, but at that point, it's not the point to go en banc. So there are at least three judges who believed that what the district court did was reasonable. Doesn't that make it a close question?
Your Honor, I'm not sure if the closed question analysis is really a factual inquiry. Like if what they meant, again, because I'm not familiar with those cases, but what they might have meant is if it's a factually closed question, maybe we need more of a record.
No,
if it's
it didn't say
legally,
factually, it said legally close constitutional question.
Your Honor, we think the answer is actually is clear as a matter of law.
You said it's novel.
It is not the scenario in which this arises is a novel scenario, but we think the court was correct. I'm not going to concede that it was close in that sense. I think it is novel. So not a lot of cases like this. But ultimately, the question is, when the president invites reporters into the Oval Office, is he creating a First Amendment forum? I think the answer to that is clearly not, because they are not being invited to engage in private speech. That makes it unlike all of the forum cases, including the non-public forum cases that the AP relies on. And because it is highly selective, the White House is inviting particular outlets into the Oval Office. It is not a situation, again, like all the non-public forum cases where an area is being held open more generally to a
Let me
wider
ask you
group.
this in the retaliation context. Let's suppose there, when members of the public, families visiting from Kansas or whomever, seek to visit the White House, they go online, apply for the pass to do the White House tour, and once they run through all of that and they meet whatever those criteria are, the White House then reviews social media, and if a member of the group has criticized the administration, then their visitor pass is revoked. Does that violate the First Amendment retaliation? Is that a First Amendment retaliation claim?
So, Your Honor, I think that if the White House has a system where it's generally open for tours, but you have to meet certain basic eligibility criteria, that looks more like the briefing room, where it's open to all bona fide journalists. And once the government opens it to all bona fide journalists, they can't then impose additional viewpoint discriminatory restrictions on entrance. But I think that's very different from invitations. If the president wants to invite into his office a set of Republicans.
I'm not talking about this in the as far as a viewpoint discrimination forum analysis. I'm saying First Amendment retaliation.
Oh, yes, Your Honor. But I don't think you can actually split them apart, because I think if we're dealing with a context where viewpoint discrimination is permissible, then it doesn't really make sense to apply retaliation frameworks at all.
I'm talking about, in my hypothetical, a family visiting from Kansas, and they are initially told, you can come to the White House, here's your tickets. When they show up, they're told you can't come in because you criticize the administration on Facebook. Does that family have a retaliation claim under the First Amendment?
Your Honor, I think if they do, it would be because this is a context where viewpoint discrimination is not permitted, because it's been held generally open. I'm not sure that's the answer, but I think that if that family did have a claim, it would be because the analysis would be the White House has made this generally open. By making it generally open, it's essentially created a type of forum. Once it creates a type of forum, it can't discriminate based on viewpoint, and therefore withholding that benefit based on viewpoint would constitute retaliation.
That's not the way you argued it in your brief. The way that you argued the retaliation claim in your brief was that, well, there's no right to access the Oval Office or to be a part of the press pool. And because of that, there's no material adverse action that's happened against you for First Amendment retaliation purposes.
Right.
Did I get that wrong, or is that
No,
the way
I
you
think
argued it in your brief?
I think you're right. What we said is there's no materially adverse action in that context. Your Honor, can I give an example that I think may help
Well, I want
illustrate
you to
this?
stick with my hypo. So family from Kansas, if they're not allowed to come in, is that a materially adverse action against them or not?
I think probably it's not, Your Honor. But the point that I really want to make is
So
that
then there's no First Amendment retaliation claim for the family from Kansas.
I think that probably is correct. But the point that I want to emphasize, if I can, is that the viewpoint discrimination and viewpoint neutrality distinction can't be taken separate and independent from the retaliation framework. Think about, for example, a situation where you have a job that under Rutan, the government can make available only to, on a viewpoint discriminatory basis, a senior policymaking official. If somebody applies for that job and doesn't get it because they have publicly criticized the president, they couldn't say, oh, I have a retaliation claim. because we all understand that's the type of benefit that can be withheld on a viewpoint discriminatory basis, even though in many, many contexts, not being hired for a job is going to count for a retaliation claim. You know, under Title
We
VII.
held that a prisoner can't be transferred to another prison is retaliation for exercising his First Amendment rights. Is that case wrong, or aren't we bound by that case?
I think that's right. And I
Do
don't think
prisoners have a right to reside in a particular prison, not be transferred?
I don't think it's about whether they have a right, but I think that there is I do think the government could not assign people to prisons based on viewpoint. And so because that is true, it is also true that they cannot retaliate based on viewpoint by transferring someone from one prison to another. But again, it comes back to, is this a context where we can grant or withhold a benefit based on viewpoint or not? If it is, then turning it into a retaliation claim, I think, doesn't add anything. And if it's not, then we're in the opposite position.
So just so that we're clear, in your view, the White House can deny members of the public from visiting and taking a tour on the basis of viewpoint, and that's not a First Amendment retaliation.
Your Honor, I think that's probably right, but I think the distinction, the reason that case is different from this case is because in that case, in your Honor's hypothetical, the White House is generally opening up the area to tours. And so there would be a better argument by that family that by doing so, the government has created a type of forum that requires it to be neutral. They haven't done that
Why does
here.
forum analysis have anything to do with it? What communication is the family engaging in when they do the White House tour?
And Your Honor, in that sense, it's the same. So on that, I think there's two criteria that we're looking at when we're trying to figure out whether something is a non-public forum or not. One is it being open for private expression? And the other is how restrictive or selective is the process? Those to me are the two criteria. I think Your Honor's hypothetical is stronger as to one and is similar to our case as to the other. So overall, it's a stronger case than the AP has here, and how it shakes out,
But the family from Kansas still loses, in your view.
I mean, if I had to take a position right now on that question, that's what I would say, but I think they have a better claim than the AP does. Because
Woe to the public.
Excuse me.
Woe to the public.
Well, if the president wants to invite particular people into the White House, because of their political views, I think the president is allowed to do that. The president routinely invites Republicans and not Democrats into the Oval Office for ceremonies. Nobody thinks that he has to extend those invitations on a viewpoint neutral basis. And I think for the same reasons, he can invite favored reporters and not disfavored reporters to watch that ceremony in the Oval Office.
So the district court found that the Associated Press, when they are operating as part of the press pool in the Oval Office on Air Force One at Mar-a-Lago, was engaging in communication, that they're practically live streaming, that they are communicating with their editors, asking questions, breaking news, found those things as a fact. I didn't see anywhere in your brief that you challenged those findings of fact.
Correct.
Did you challenge those or not?
No,
Okay, so none of those facts are challenged.
we have not challenged those facts.
So then why isn't that dispositive on the issue as to whether or not they are communicating, engaging in communication when they are part of the press pool?
Your Honor, I think they're engaging in communication. Our point is that communication is not tethered to the physical place. So it may well be that when they're in the Oval Office, they're texting. They can also do the same thing an hour later when they leave. The purpose for which they're being invited in is to observe, to have access to that information. And so we think for that reason, this case is better analyzed as an access to information case like Baltimore Sun, and not a forum case where ordinarily with a forum, you are being invited in and the speech is happening in the forum, and that is the purpose of the forum. So it is.
So what about the Brady press room?
So the Brady press room is part of a broader complex in the White House where the journalists and reporters are doing all sorts of speech activity. They're asking questions, they're doing interviews, they're typing up their stories. All of that is happening in that space, and that is what the space has been designated for.
The district court found that they asked questions on Air Force One. They asked questions in the Oval Office.
That's not the way the AP is litigating the case, though. They're disclaiming any interest in asking questions or speaking because they recognize that when they go down that road, they are running into government speech interests on the other side. So they have not claimed they have a right to ask the question and have it be answered or have any sort of interactive exchange with the
There's a
president.
difference between saying you have a right to have your questions answered and just acknowledging. I mean, no one, when they're in the Brady press room, has a right to have their question answered.
That's right.
But what happens there is that they are observing whatever the president or the press secretary or whomever is saying. They're reporting on that, and then they may or may not ask a question. It may or may not get answered. Why isn't the exact same thing happening if you are part of the press pool and on Air Force One?
So, Your Honor, there are two differences between the press area and briefing room on the one hand and the Oval Office and Air Force One on the other. One that we've talked about a little bit is what is the designation of the space for? And I think the designation of the press area is much broader and encompasses a wider range of speech and private expression than the Oval Office. But the second is the selectivity. So the way the briefing room works in the press area is as long as you meet a certain basic eligibility threshold, you're allowed in. And so that gets it into the non-public forum category under forum analysis. That is not true anymore, at least, of the Oval Office or Air Force One. That is by invitation only. The president is extending the invitation specifically to the people he wants to include. That is inconsistent with the notion of a forum. So I think that's one difference. I will say, though, they are
You are saying that we're supposed to consider this based on the White House adopting a new and different approach for the press pool. But the district court didn't rely on that in entering the preliminary injunction, did it?
I think it did, Your Honor. I think it's been conceded throughout that the president and the White House is allowed to change the sort of structure of the way the pool works, and that nobody was challenging, for example, the insourcing of the selection. So, it used to be done by the Correspondents Association, and it's been outsourced to them to pick. White House brought that back in and said, we're going to decide day to day who we're inviting. And nobody has said that that's not allowed. And the whole case has been litigated on the premise that that much was permissible. So then we're at the point of analyzing what are the implications of that for forum analysis. And that level of selectivity is inconsistent with any type of forum.
But this is my point is that why does that make any difference on the legal question, whether it's the White House Correspondents Association or the White House itself designating who is in the press pool?
Because, Your Honor, if the White House is choosing who to admit on a very selective and restrictive basis, then it is not the forum principles, even from the non-public forum cases, don't apply, because it is not a situation where it is being held open in any sense. It is purely a matter of invitation. And when it's a matter of invitation, we don't apply viewpoint neutrality principles. For example, the White House wants to hear from advocates on one side of an issue. It can invite them in to make a presentation. It doesn't have to let the other side in to make their presentation, right? So when you're dealing with that sort of invitation selectivity, we don't apply the same viewpoint neutrality rules as we do in forums, even non-public forums.
So the White House could, for the annual Easter egg roll, send out invitations only to the members of the public whose speech it agrees with, and reject others, and there be no First Amendment problem in your view.
Your Honor, I think that's clearly true. I mean, there are events all the time at the White House, parties, receptions, ceremonies where the president is going to be and the White House is going to be inviting people based on political affiliation, where ordinarily under the First Amendment, in many contexts, you can't discriminate based on political affiliation. But nobody's going to come up here, I don't think, and say, yeah, the president has to invite equal number of Republicans and Democrats to the Christmas party. That's because it's not a forum.
Mr. Roth, can I ask you, in your brief, you talk about the fact that the injunction restricts the president from making his own decisions. The injunction here, though, is not at least formally directed at the president. I mean, if the White House staff were to follow the injunction, but the president chose to say, I don't want you here in the Oval Office, what would be the consequence of that? I mean, is this injunction here effectively an injunction against the president?
Well, I think it means that the White House staff can't follow the president's directives while also complying with the injunction. And so that is.
So is that an injunction against the president?
I mean, in form,
I don't see the government seems to perhaps allude to that argument, but not make that argument in the brief. And I'm wondering.
I don't intend to be making that argument. I mean, there's this general rule that, the courts don't enjoin the president directly in the execution of his duties. And the courts generally do that by just carving out the president from the scope of the injunction and telling everyone who implements the directives to follow the injunction. And nobody has a problem with that.
Does that fiction really work when we're talking about White House staff who are directly working for the president, who are assistants to the president, deputy assistants to the president? I mean, it might work in the context of an agency, much more removed from the White House.
Well, certainly true that this is much closer to the president's own personal sort of prerogatives and decision-making. And so it is more sensitive in that way. And I think, as the state panel discussed a few months ago, leads to much more difficult compliance questions and administrability questions, because we start to get into factual debates over, why did the president choose A instead of B? How are we going to figure that out? Who are we going to call in to make that determination? So I think for all those reasons, it's sort of more fraught than in the ordinary injunction.
It seems AP can't really get the relief it wants without an injunction against the president, because the president controls who enters the Oval Office and Air Force One. And if the president says, I don't care what my press secretary says, I don't want AP on my plane, I don't see how the injunction can actually get AP what it wants.
It certainly.
I don't see how that works.
It would lead to a lot of conflict within the White House, I think, is maybe Your Honor's point. We don't want the president's assistant.
If it would lead to conflict in the White House, I think if the president said, I don't want someone on my plane, I don't want someone in the Oval Office, my personal office, I'm not sure.
I take the point, Your Honor. Yeah.
Well, if that's the case, then why isn't any injunction against the cabinet secretary or any executive official problematic? Because the president could disagree and order the Secretary of Health and Human Services to, grant that Medicaid exemption to that hospital. We don't care what the court says.
Your Honor, I don't want to put words in Judge Rao's mouth. I think the point that she was making.
You agreed with the point, so tell me why my concerns about the point aren't.
I think the point that she was making was that these decisions that we're talking about are much closer to the president personally, right? He is in his office. He is getting on his plane. He is making decisions about what is happening in his immediate vicinity. And that is unique. I mean, we've seen a lot of injunctions over the last 9 months, but this one is unique in how close it gets to the president's own space and this personal decision making.
Well, part of my argument is that either you can enjoin the president and tell him that he must let AP into his office, or the president can decide who he lets into his office. It has to be one or the other. And it's not the same thing when you're talking about a cabinet secretary following the law or some statutory requirement.
Well, Your Honor, thankfully, I think that sort of even apart from that, the injunction doesn't work as a matter of law because it gets the First Amendment principles wrong, and specifically gets wrong when we apply the principle of viewpoint neutrality and when we don't, and the line between a non-public forum and something that is not a forum at all. And for those reasons, we think the injunction should be reversed.
Do you really want a room by room, space by space jurisprudence? It seems to me what this case is all about is access to the president. I don't know why, if you start with the proposition, like the Oval Office hosts any number of different events, bill signing, press conferences, rallies, meeting with the head of state, and press might or might not be in there, and the president gets to decide that. And it's really different if the event is moved from the Oval to the Rose Garden or the East Room or somewhere else. And, you know, President Trump, Inauguration Day, had an event at the Verizon Center. I mean, I assume people who got those tickets were supporters and not opponents. And if he did a press conference at those events, probably the reporters he's talking to were supporters rather than opponents.
Your Honor, I don't want to be too categorical, because I do think part of the analysis turns on how the government is itself treating the space and treating access to the space. So if the president did a briefing in the Brady briefing room, then I'm not sure we would have the same arguments because of the way the government itself has set up that space and allowed access to that space. Well, I think under this court's decisions,
I know you have a TEBA and you need to distinguish that,
Yes.
but
I think we can distinguish.
TEBA and Cheryl are about hard passes, and they're about 1,300 journalists who get them, and they're about 50 seats in the Brady briefing room. I'm not sure those cases stand for the proposition that access to a presidential event in the briefing room can't be curated.
Your Honor, we haven't pressed that because factually the White House hasn't tried to press it that far, right? The White House has accepted there is this area within the building that is generally open. Once we say it's going to be generally open, we're kind of stuck with that. And therefore we have a viewpoint neutrality rule that attaches. All we're saying is that that doesn't carry over to areas that are not generally held open for private expression, including the office.
Just so I want to make sure I understand your argument and the distinctions you're making. So are you agreeing that the White House, it would violate the First Amendment for the White House to revoke a hard pass because of disagreement with the reporter's coverage or the reporter's company's style guidelines?
Yes, Your Honor.
And why do you agree that that would violate the First Amendment?
Because those passes have been made available on a sort of generally open basis to everyone who meets the threshold eligibility of a bona fide Washington journalist covering the White House. And under this court's cases and the Supreme Court's cases, once the government opens up a space, either physical or metaphysical, on that sort of open, generally open terms, then it becomes a non-public forum, and therefore viewpoint discrimination is not permitted. And so this court applied those principles in Ateba and said that covers the hard pass system. The question here is does that carry over to spaces that are not generally held open? And they're certainly not generally held open for private speech like the Oval Office. We think the answer to that is no.
And isn't it also the First Amendment retaliation claim separate and apart from whether it violates the First Amendment under forum analysis?
I don't think I don't think that the label changes what's fundamentally driving the outcome. So if we're dealing with the press pass, you could call that a retaliation claim rather than a viewpoint discrimination forum claim. And it would apply exactly the same way. Meanwhile, if we're talking about, somebody who's invited into the Oval Office to make a presentation about, let's say a pro Second Amendment presentation to the president, then an anti-Second Amendment advocate couldn't bring a claim and say, oh, I didn't get the same invitation, I was retaliated against. We would say, no, that's a context where the viewpoint discrimination is allowed by the First Amendment. So you have neither a forum claim nor a retaliation claim.
Well, I thought a few minutes ago you said that the family from Kansas, if they were initially accepted to take a tour of the White House, but then were told when they got to the gate, you can't come in because of your social media criticism of the White House, that wouldn't pose a retaliation problem.
So that, because the tour itself is, I'm not sure that getting the tour or not getting the tour is going to even meet the sort of minimal threshold for any retaliation claim. So I think there's kind of two ways a retaliation claim might fail. It might fail because you're allowed to do viewpoint discrimination. It might fail because it's just not the type of action that can qualify for retaliation at all. Like if I make an angry face at somebody, that's not enough for retaliation, right? The tour, I'm not sure if it rises to that level.
Do you think that what you're arguing now comports with the Supreme Court's decision in Wilson?
In which case?
Wilson, it's the one you rely on in your brief, I believe. It's a Supreme Court decision.
I mean, for retaliation purposes, I know we invoke the Supreme Court's decision in the Houston Community College case, which says when you're trying to figure out whether an action is materially adverse.
College v. Wilson.
Yeah, you look at the sort of historically, how has this been treated, and make the evaluation in light of those sort of background norms. And I think our argument is entirely consistent with that, because especially when you view this case through the access to information prism of, what is the historical relationship between the president and the press with respect to information? And I think that's actually an area where the merits briefs have a lot more to say than the state briefs did about that historical relationship. And I think it makes quite clear that presidents have always treated access to information as both a carrot and a stick with the press on viewpoint discriminatory terms. And that, I think, further supports our point on retaliation, which is that this is just another instance of that sort of relationship, and therefore
Wilson
is not.
said that if distinguished that case from an instance where the government prevents the person from doing their job, and distinguish that case, which was a censure of an
Legislator.
representative, from cases that are aimed at private individuals and the sovereign taking action against private individuals, and uses the example of the Whiskey Rebellion and how there were efforts to try to punish private citizens for their participation in that was quashed by James Madison and others. So why isn't when the district court finds that the AP is inhibited from doing their job, and in fact, that's the precise reason why they're being punished this way, you don't generally impose punishments that don't hurt. At least I don't. So why isn't this square on what Houston Community College v. Wilson is talking about?
So, Your Honor, I'm not making the argument that it doesn't hurt. What I'm making, the argument that I'm making is that journalists and reporters need information to do their jobs, right? They all need information. They want information. The more information they have, the better they can do with their jobs. And yet, it has long been the case and accepted that elected officials can give and withhold non-public information to journalists on a viewpoint discriminatory basis. That's why we have the interview example, but not just interactive, not limited to interactive episodes. Things like leaks of information, things like exclusives, heads up, call somebody and return somebody's calls to answer a question, right? All of these things are are ways in which the public officials can selectively provide access to information to favored journalists. And that has been happening, as our brief develops, I think, in greater length, for a very long time. And nobody has thought that that violates the First Amendment. And so against that backdrop that Baltimore Sun talks about at length, against that backdrop, this type of selective restriction on access to information is not properly considered a materially adverse action for First Amendment purposes either.
All right, thank you. We'll give you some time on rebuttal.
Thank you, Your Honor.
Mr. Tobin, we'll hear from you.
Thank you, Your Honor. Charles Tobin from the law firm of Ballard Spar, along with Max Michigan, Sasha Dunning on behalf of the Associated Press. Your Honors, I think Judge Wilkins, your question was very apt in terms of what is the standard of review here. Obviously, we have had numerous judges weigh in on this case. And as the court pointed out, Judge Walker wrote a decision on bond concurring as a matter of procedure in the denial of review, but he did write that the trial judge wrote a forceful and persuasive opinion, and that the court ought to give it due course and due reason. Your Honor, that makes this particular argument, whether to reverse the injunction wholesale, very different from the state panel's setting. We've now had several judges take reasoned and opposite positions based on their own views of whether it's an access case or whether it's a retaliation deprivation case. That makes it, at least in the minds of this court, a close question of law, and that requires a higher level of protection for the district court's decision below. And Your Honor, we believe and we ask that the district court, that you agree with the district court, that the First Amendment does not stop at the Oval Office door. This case is governed by Sherrill and Atiba and Karam. We have a well-reasoned line of decisions that say that once you have a system that allows the press into a certain location, whether it's the White House or in Sherrill, whether it's Karam, the Rose Garden, or whether it's Atiba, the Brady Press Room.
Well, what's the system here? I mean, the White House is now choosing who gets to observe the president in the Oval Office and Air Force One. What's the system other than these are people who we have decided we will favor with access to the president?
Your Honor, to ask the question the way you have asked it answers the question with all due respect. The White House now has a formalized policy. It was established on April 15. It's written down. It's 2 pages. It has multiple points. In assuming the obligation, the responsibility for being the gatekeeper for the press, the White House has now directly taken on the obligation to abide by the First Amendment in making those selections. And whether this case is decided on a viewpoint, on a public forum basis, or a discrimination basis, or a Fifth Amendment basis, the First Amendment commands no viewpoint discrimination. And the White House press policy.
AP has conceded that the president can discriminate on the basis of viewpoint with respect to interviews or who he chooses to meet with. And AP tries to draw a distinction between physical access and personal access. But where the president is concerned in his most, sort of his own personal spaces, like his airplane or his office. I mean, don't those two things collapse? I mean, how do we distinguish between just physical access and personal access when someone is within 10 feet of the president of the United States?
Your Honor, they are not his personal space, with all due respect. Those are the paid for by the taxpayer, people's offices that the government is conducting government actions for the people.
I mean, they are government. Of course, they are owned by the government, but the president he's the head of the executive branch, and this is his office that is given to him, by Congress and by the government to do his constitutional duties.
And Atiba
you think that's the same as the Brady Press Room?
I think Atiba speaks to that directly in dividing the government spaces in the White House between the president's living quarters on the one hand and government offices on the other hand. And just like the president is not above the law, the Oval Office is not a First Amendment banned forum for the purposes of conducting the government's business. When the president invites the press pool in, he is operating under a regular government system. And I think the government, in its argument, my friend on the other side, conceded his case when he said, if the White House has a system open to all bona fide journalists, that looks more like the White House briefing room. And that is exactly what the press policy has been since the Eisenhower administration and is now being run directly by the White House. It is a government system for allowing a group of journalists that is specifically defined in the policy as the pool into any space where the president is conducting business.
So you're backing off all of the concessions that you made at the prior argument.
I'm not.
You said at the prior argument, the White House can choose to admit one favored journalist or 5 or 20 to the Oval to access the president.
I was acknowledging that that's the law under Sherrill, and I was acknowledging
that the White House can do all of that on a viewpoint basis.
That's what Sherrill says. Sherrill says this case does not involve the right of the president to speak to whomever he wants to. But the Sherrill case, which governs here, and the only way the government wins in this case is if this panel were to overrule Sherrill, Karam, and a table what it's specific.
So you need, in order to prevail, you need for there to be a First Amendment distinction between Oval Office events, depending on who is going to speak to whom. If the reporters are going in with an expectation that they can ask questions and have them answered, the president gets to pick. If they're going in to be silent and observe, First Amendment attaches.
No, Your Honor, I would say the distinction is if it's a pool event, which we now have as a defined thing under regulation directly by the government. If it's a pool event, then the president cannot pick and choose people the way he could if he's inviting an individual or
He can make ad hoc judgments about whom to come into a particular event.
That is the law of this circuit, that it's a particular event.
He can't do that. He can't memorialize on paper a rule that we're going to pick reporters based on who we think is appropriate to the event at hand.
That is not what this pool system is, and that is the law under Sherrill, that once there is an established system, whether it's a hard pass system or a pool system, there is no principal distinction as a matter of law between those two, unless we're going to stop the First Amendment at the Oval Office door. And that is not a principle on which I think this court should rest. That is not consistent with the applicant.
How does the president, on your view, given what you say is an established system, how does the president get to pick who will come in the Oval Office for an event on a viewpoint discriminatory basis?
Because it's not a pool event. If he's sitting down with Tucker Carlson and having a one-on-one interview, that is not an invitation to the pool.
Suppose he has a foreign head of state in the Oval and he wants a couple of reporters to observe it, but he doesn't want reporters who might ask the foreign head of state an embarrassing question. Can he do that?
If it's a one-on-one or a two-on-one,
or a 3-on-1 or a 10-on-1?
Yes, Your Honor, because but I'm not, if I may, that is the law in Sherrill, and I can't ask this panel to overrule Sherrill. It doesn't have the authority to do that. That is the mundane practice of that's the historical and mundane practice of individual interviews. That's one thing. We also have a historical practice with its antecedent roots in the Garfield administration, but being formalized during the Eisenhower administration. We've had 70 years of experience under a system called the press pool and a defined set of events. The White House sends out emails every night defining who the members of the pool are going to be for the next day. That is an established government system that looks an awful lot like the mailbox in the Perry case or the CFC flyer in
So
the
your whole argument
Cornelius
turns on
case.
the press pool being a system. I mean, the system has changed over time. I mean, it was run by the Correspondents Association. Now it's run by the White House. I mean, it's not some fixed thing. The
Well,
press pool.
it has changed in some of its
It's
dimensions.
changed in it's who is part of it, how it is selected, who does the selection. I mean, these are the key components. I mean, there's no historical practice of a fixed press pool.
Well,
I mean,
you're
if that's AP's primary argument, then I don't see how.
Well,
it
a
gets you where you
form is
need to go.
defined by historical precedent, historical antecedent, whether it's people are allowed in to speak and whether it's governed by reasonable and viewpoint neutral criteria. That's what happened in the Perry case. That's what the mailbox system in the Perry case. That's the second-class mail system in the Hannigan versus Esquire case from the United States Supreme Court. You have the government establishing a system, and it may change in dimensions from time to time, but in every case, it must be administered. If it is a government program, which this is, it must be administered in a content neutral, a viewpoint neutral, in a reasonable
So
manner.
there's an event scheduled in the Oval. Does the White House get to designate that event as press pool or something else?
They do it all the time, Your Honor. That's
Okay.
routine practice.
And are they bound by viewpoint neutrality when they make that designation?
We are not arguing for viewpoint neutrality when it comes to individual
They
decisions.
just
by the president.
designate the event as a non-press pool event.
We're not arguing that if it is not this case is strictly being argued under the facts of the press pool case and under the undisputed findings that the
I
district
mean,
court
but then
made.
it sounds like a jurisprudence of labels. They call something the press pool. The press pool is just a mechanism for allocating space in the Oval or on Air Force One or wherever.
Well, it's a defined government program. I mean, the public forum doctrine is jurisprudential labeling, right? You have traditional, you have limited or designated public forums, and then everything else is a non-public forum.
If you win on that theory, the next day, the White House will stop designating things as press pool events.
We might have something to say then under our retaliation claim, Your Honor, if it is done to cut off the AP's right to call it the Gulf of Mexico during the middle of this litigation. We also might have some things to say about it being retaliation for this litigation, as we did in our amended complaint. So it would not end the inquiry for us if the White House were to do that. I'm only acknowledging, Your Honor, that the president does have a right, as it says in Sherrill, and is established law in this circuit, that the president can make individual decisions. It's also established in this circuit that if the White House has a hard pass program or admission for all journalists to the East Room or the Brady Press Room, he must not discriminate based on viewpoint
Can I ask you a
criteria.
doctrinal question? So you said that everything else is a non-public forum. I mean, do you agree that there are some government spaces that are not fora at all?
I agree there are spaces that when they're used for certain purposes are not public fora.
Can
President
you
Meade-
give me an example of what
Sure.
would be a non-forum government space?
I would say that analytically, I would argue that they're all non-public forum because of the everything else.
Is my office a non-public forum? Is a member of Congress's office a non-public forum?
Certainly, if it is used, if you were to hold a hearing in your office, and I've had this experience, Your Honor, with trial courts holding in-chambers hearings, the First Amendment follows the ceremony of the proceeding. So if a member of Congress is holding a pool event in their office, then certainly it falls under
If a member of
public forum.
Congress is meeting with a handful of journalists or making an announcement in their office, the viewpoint neutrality attaches to that space?
Not if it's an individual invitation-only event. That's the a functional equivalent.
But that distinction doesn't, I mean, how do we decide what's a pool event and what's an invitation-only event? I mean, as Judge Katsas said, is it jurisprudence of labels? I mean,
That's all we have to go by at this juncture, Your Honor. If the injunction were to hold, the president could not eliminate from, and it's a very narrow injunction. It simply says events open to all press, the AP cannot be excluded based on viewpoint. And that's a simple holding. I think the judge, as Judge Walker and Judge Pan agreed with him, said it was a forceful, eloquent, but it was also a very narrow remedy. And the remedy is simply that if it's an event open to all journalists in a pool or otherwise, whether it's the East Room or the Oval Office, you cannot discriminate based on.
let me ask you about the remedy. So is this injunction effectively an injunction against the president? So it's formally against his staff or members of his staff. So if the president chooses to say, well, you know, I understand my staff has allowed AP in for this particular event, but I would prefer that they're not here. Please leave my office. Then what happens?
Well, we took our cues from Judge Tatel's decision in the Karam case, which upheld the injunction in that case, except he carved out the president for reasons of respect, I think, for separation of powers, if I remember how he
Well, that
phrased
and
it.
Supreme Court precedent saying you cannot enjoin the president.
And so, Your Honor, I would say if first of all, my friend on the other side is right. The White House could not execute the president's orders without violating the injunction if you uphold the injunction, and that makes it a very practical problem for the White House. And certainly we would be in court if the White House press secretary, despite an injunction, said the president has ordered me to do this and I am going to carry it out.
What if the press secretary isn't doing it? The president simply escorts out the disfavored journalist from his office. Now
Well,
what? Now can you go back to court
I
and
presume-
enforce that?
I presume the people escorting him out would be the White House
Well, the
staff.
president just, walks him to the door, sends him into the hallway and says, please, you are no longer welcome in my office.
He's
And
a
so
pretty
you're
big
back
guy.
you're back in court before the district court saying now we want an injunction against the president?
No, I would say we want an injunction against the White House staff not to follow the president's orders, and we
But
would
they
work
haven't
it.
done anything. They haven't
would-
done anything. The president has simply escorted a journalist out of his office. The staff just stand by.
Then I would be on the phone with White House counsel's office. We would have a spirited discussion about whether we needed the court's intervention, and we would be back in front of the court saying there cannot be life given to this
You
injunction.
eventually need an injunction against the president for this to work, don't you?
I don't, at
In
this,
his office and on his plane. I mean, ultimately for it to really stick. Is that what you need?
I don't think so until the president decides to disobey the spirit and the First Amendment and decide that he is above the law. The president is not above the law. I
No,
would
he is
expect
not.
him-
And the government is not alleging that the president is above the law in any
I
way.
would expect him to respect a ruling of this court that says the government may not discriminate on the basis of viewpoint. Yes, I would expect the president to observe and respect the decision of this court that says that.
Do you think there's any problem, though, with the fact that for something like this to work, where there is physical and personal access to the president of the United States, it suggests at least some reasons why an injunction like this is inappropriate?
No, Your Honor, not if we start with the proposition that, number one, the propositions that the president is not above the law, that the First Amendment applies to the executive branch, restricts the authority of the executive branch. Everything else does not depend on the specific physical situation. It depends on whether there is an established system like the press pool that allows you into the Oval Office. And so the intimacy of the space doesn't matter any more than the restrictions on Guantanamo Bay in the Nation magazine versus DOD case. The court held that restrictions on access to Guantanamo Bay had to be applied to the press viewpoint neutral, that flights to China during the Red Scare, which were limited to journalists, according to Justice Berger, when he was on this court, could not be meted out to Republicans or Democrats. They had to be assigned in a viewpoint neutral way. And so either we believe in viewpoint neutrality wholesale or we write it out of the law completely. It is not a situational ethics, not a situational specific pattern that drives these. It's the overarching and as of now, unbroken line of precedent that says that the government cannot discriminate on the basis of viewpoint in meting out any right, benefit, or privilege. And as my friend said on the other side, that's really what we're talking about here.
Could I ask a few questions about
Please.
retaliation? So you have the three-part test, which turns on whether there's a materially adverse impact. And that sounds like a very good test for you, and it generally applies to denial of benefits. But I wonder if it needs to be qualified in the very limited contexts where viewpoint discrimination is permissible. I think that was Mr. Roth's theory. So to just take a case where viewpoint discrimination is permissible, presidential speech, president is gets in a tussle with a reporter whose viewpoint the president disfavors, and he speaks to the nation and says, this man is a scoundrel and don't listen to his opinions. He can do that, I assume, right?
He's done it twice in the last week, right?
Okay.
He called a
but-
Bloomberg reporter piggy, an offensive phrase. He did it on national television. He did it in Air Force One, not in the residence of Air Force One, but in the press section where he chose to come back and engage with the
And
press
you
during a
wouldn't-
pool opportunity.
And you wouldn't say that that reporter could bring a retaliation claim and prevail by invoking the three-part test and showing a material harm to the reporter's business?
By calling her an offensive name, no, Your Honor, I think that's settled law that the executive can speak offensively, as offensively as he
so-
likes, and this president does that routinely.
So that's one. Take another one. One-on-one access to journalists for interviews. You've conceded, I think you still say, the president can make those decisions.
That is the law of Sherrill
Okay,
versus.
so a journalist is scheduled to come in for an interview. The day before the journalist criticizes the president cancels the interview. No retaliation claim there, I assume, right?
I think it's a closer question, Your Honor. I would not advise my client on that single event to bring a retaliation claim. If they were then
Okay.
excluded from the pool and they had been assigned to a pool rotation, I would be back here making that same argument.
Baltimore Sun decided sort of under the three-part test where the court says, gosh, reporters are tough and they won't be deterred and they shouldn't be deterred by denial of access. Suppose there were a district court finding in Baltimore Sun that reporters are chilled if they're denied the access in that access to government officials. Retaliation claim?
What I'm playing out in my head is, are you asking me if the court found as a matter of fact reporters were chilled,
Right.
or as a matter of law it
Right.
constitutes unconstitutional?
I'm suggesting that Baltimore Sun really, and I think Houston Community College with a censure, really they stand for the proposition that there are certain kinds of government actions that don't have to be viewpoint neutral. And when you're talking about those actions, no retaliation claim when the government does the viewpoint discrimination.
We know in city of Heffernan versus Patterson, New Jersey, a police officer was demoted because the chief erroneously believed that he was carrying picket signs or campaign signs for his opponent. The Supreme Court found a valid retaliation claim in those circumstances on the theory, the legal hook, that it would chill other officers from exercising their First Amendment rights. So the chilling effect, and that's from Elrod versus Burns, the chilling effect on others is very relevant. In this case, we don't need to look to others. We can look directly at the record. The Associated Press has lost revenue.
Sorry, I'm spotting you that. I'm spotting you, Harm.
Thank you.
I'm just wondering whether it matters. And who's the plaintiff in the case you just mentioned? If it's a low-level government employee, sure, you can bring a retaliation claim because that employee has a First Amendment right not to be discriminated against in government employment based on his viewpoint.
What about the
If it's the Secretary of State?
What about the Toolsparad case that Judge Wilkins asked about? That's this circuit's law that involved a prisoner who has the least amount of rights of just about anybody in society. That prisoner, because they were practicing the Hindu religion, was being discriminated against and got transferred to another prison. And this court found a
And
cause of
nobody
action.
thinks viewpoint discrimination is permissible in assigning prisoners to prisons.
I'm sorry, I didn't hear your question.
Sorry, viewpoint discrimination in that context is impermissible.
It is impermissible. So I'm
Therefore,
answering your
there's-
question about the low level. Is the doctrine, as I understood your question, is the Heffernan doctrine limited to low-level government employees? I was picking another fact pattern that is the law in this jurisdiction that applied to somebody who has the lowest level of protections in
Yeah, but
general.
I'm asking you, but my concern goes to the high level government employee who doesn't have a right not to be subjected to viewpoint discrimination.
And the question, Your Honor?
Suppose a cabinet secretary is fired for that person's viewpoint. Retaliation claim or no?
I think that there, the president has greater authority when there are people who speak for his policy. And I agree with my friend about
The
that.
president can discriminate in that context based on viewpoint. And therefore, this is what I'm getting at. And therefore, that person has no retaliation claim based on the viewpoint discrimination.
I think they're more restricted than the press, than the rights reserved to the press under the First Amendment and the doctrine of this court in Sherrill, Ateba, and Karam, which this court obviously would need to overrule if it were going to rule for the government.
Thank you very much.
Thank you, Your Honor.
All right. Thank you. We'll hear from Mr. Roth. You were out of time, but we'll give you 3 minutes.
Thank you, Your Honor. So it sounded to me from counsel's argument like a lot was hinging on giving pretty talismanic significance to the use of the word fool. And I don't really think that makes sense. The pool is just the name for the people who are being invited in. And the question is not, the First Amendment shouldn't turn on that word. It should turn on the substance of what it represents.
But I thought your argument was that forum analysis is based on location, situs.
No, I think it's based on two things. And the one that's relevant to what counsel was referring to is this question of selectivity. Is it open or is it selective? If it's selective, it's not a forum. And the pool, as it's currently constituted, as Mr. Tobin said, it's just the list that the White House sends out the night before that names the people who are invited in. That is the most selective regime one can have. They are dictating who can come in and who cannot by name. And in that circumstance, there is not a forum. It is just an invitation to those people to enter. Just to give a sort of an analogy that I was thinking about, if the White House had a system where they said every Sunday morning for 2 hours, we're going to let citizens come and present petitions to the president on whatever they want. That might be a forum, right? They're saying, private speakers, have your chance to speak. It's generally open. If they've said, however, we're going to do this presentation where we're going to invite people to make presentations to the president, they could choose the topics and viewpoints of those presentations. So as with much of forum doctrine, it turns out to be a little bit of sort of truth in advertising rule, right? If you are holding it open as open, you need to actually walk the walk. If you are overtly picking and choosing, we don't have a First Amendment problem. And I think that's the sort of the core of why this injunction should be reversed. And thank you, Your Honors, for the time. We would ask the court to reverse the injunction.
Thank you. The case is submitted.
Thank you, Your Honor.
Case number 24-1363 et al. Public Safety Spectrum Alliance and Public Safety Broadband Technology Association petitioners versus Federal Communications Commission and United States of America. Ms. Amundsen for petitioners Coalition for Emergency Response and Critical Infrastructure et al. Mr. Obervol for petitioners Public Safety Spectrum Alliance and Public Safety Broadband Technology Association. Mr. Kandu for the respondents. Mr. Turner for interveners, National Fraternal Order of Police and Public Safety Spectrum Alliance.
Good morning, Ms. Amundsen.
Good morning, Your Honors. May it please the court. My name is Jessica Ring Amundsen, and I represent the Coalition for Emergency Response and Critical Infrastructure, along with our co-petitioners, the San Francisco Bay Area Rapid Transit District, the National Sheriff's Association, and the California State Sheriff's Association. In the Spectrum Act in 2012, Congress created a new federal entity called FirstNet and then ordered the commission, which otherwise does not have authority to grant licenses to federal entities, to reallocate a specifically defined 20 megahertz of spectrum from public safety entities to the new federal entity, FirstNet, and to issue a, quote, single license to FirstNet. In the order under review without any further statutory authorization, the commission granted FirstNet and by extension, its commercial partner AT&T, which operates the FirstNet network, access to an additional 50 megahertz of spectrum on an entirely different band that for decades has been dedicated to use by state and local public safety entities. The commission used a workaround to circumvent the statutory prohibition on its authority to issue licenses to federal entities directly, but each step of that workaround is independently contrary to law. The commission.
This order is it's a very odd combination of being final on some questions and interlocutory on others. I take your point that all of this seems geared to shifting spectrum from incumbent licensees to FirstNet. And that seems problematic when the FCC is doing it and NTIA is not involved. But they say they reserve two critical questions. One is whether the band manager will ever get a license at all. And number two, whether the contemplated agreement between the band manager and FirstNet will be approved. And so if those two things are up in the air, this concern about the workaround has a little bit of a rightness question to it. I mean, it might or might not happen. So why would we strike this order now based on, I mean, if either of those contingencies fail, the workaround won't happen.
So, Your Honor, I think that the order is clear that those contingencies are going to happen. And so where you can look is in paragraph 21 of the order, where the commission says that the best mechanism for putting unassigned spectrum to use as quickly and efficiently as possible is to assign a nationwide overlay license to the band manager. And then if the court also looks at the actual ordering clauses and the rule that the commission adopts, which is at JA 706, the new rule 90.1217, the band manager is charged with, quote, managing a sharing agreement with the First Responders Network Authority. So the commission is quite clear that while I think they are trying to sort of reserve some things to, escape judicial review, what is happening here is this nationwide overlay license that's a pass-through to FirstNet.
And yet, I agree with that. And yet in footnote 107, they say band manager has yet to be selected. The bureaus will do that. We think this is going to work out to pick the most qualified person, and then we will review. When and only when that happens, we will review the band manager's application for a license. I don't know what to make of that.
Well, I think what the court should look to is the actual rule that the commission adopts at 90.1217, where it says that the band manager's job is going to be to manage a sharing agreement with FirstNet. That's at, I think I just had it, JA 706, where that is going to be. So
we'll have the following.
Right. So this is the actual rule that they adopt. These are the responsibilities of the band manager, and the band manager is going to manage a sharing agreement with the First Responders Network Authority. So I take Your Honor's point that at times the commission really is trying to have it both ways. They're trying to say, like, for purposes of the 309J exemption, we're going to rely on FirstNet's that it's going to offer public safety services, but because there's potentially a problem with the sharing agreement under Rule 2.103B, we're going to say it's kind of tentative whether we're actually going to grant that sharing
interlocutory
agreement.
on who the band manager is, but final on whoever it is, the band manager has to try to do the workaround.
Exactly. The band manager is charged with being a pass-through of 50 megahertz of spectrum that Congress never authorized FirstNet to use to go to FirstNet.
Ms. Amundson, so I take your arguments that FirstNet can only exercise the authorities that are given to it by Congress. But reading through the Spectrum Act, I get the sense that the initial license allocation is a floor and not necessarily a ceiling. And I'm wondering about the several provisions of the Spectrum Act that say FirstNet can contract with federal, state entities, other organizations. So if FirstNet is given this ability to contract with other entities, why wouldn't that include something like a sharing agreement with the band manager?
So, Your Honor, I think first, just to push back a little bit on reading the Spectrum Act to be sort of a floor for spectrum rather than the ceiling for spectrum. I think if you actually look through the text of the Spectrum Act,
I've done that. I've read the whole Spectrum Act.
the Congress is quite clear that it is talking about this specific 20 megahertz of spectrum. They go in section 1401, it defines it specifically with reference to each frequency. In section 1411, it instructs to reallocate the 700 megahertz D block spectrum. In section 1421,
But there are other indications as well, though, where it talks about, the authority. It says, yeah, I mean, there are contrary indications. I mean, it mentions the specific band in some places, and then in other places it suggests, that this is, I'm just looking for some of these provisions, right? That their network components will initially consist of a core network, right? And then there are several kind of, I guess what we call, like with the Constitution, like sweeping clauses, right? That FirstNet can exercise incidental powers, that they can exercise things that are appropriate to its responsibilities. And they are specifically given contracting authority. So I guess why does the contracting authority not cover the sharing agreement? That's
because the contracting authority is limited to the spectrum that Congress specifically allocated and ordered the commission to give FirstNet a license to. That license under section 1421 was, quote, for the use of the 700 megahertz. But if they already
have that license, then why do they need contracting within that band? Doesn't the contracting look outside of that band?
Because what
or in
Congress,
addition to the band?
So Congress was limiting them to the 700 megahertz D block spectrum. The contracting authority is with AT&T, which then uses that spectrum for commercial purposes.
Federal state agency? I mean, the contracting authority is quite broad.
So, Your Honor, what I think the Spectrum Act, there is no indication in the Spectrum Act that, in fact, Congress meant to grant FirstNet access to spectrum other than the 700 megahertz spectrum. And if you look, for example, one might expect that the provision on, quote, maintenance and upgrades might say something about being allowed to go onto spectrum other than the 700 megahertz spectrum. The text is littered throughout with references that FirstNet is limited to the 700 megahertz spectrum. And the text also puts very important limitations. Your Honor is talking about the limitation on FirstNet's authority. The text also puts important limitations on the commission's authority, which are very important here as well. The Spectrum Act essentially charges the commission with doing just three things. So first, it is supposed to reallocate the 700 megahertz D block spectrum and facilitate its transfer. Second, it is supposed to award the, quote, single license for the use of the 700 megahertz.
Okay, I mean, those are a couple of mentions. What about 1426B, B1D, which says, so one of the duties and responsibilities is at a minimum, they list all these things, which includes managing and overseeing the implementation and execution of contracts or agreements with non-federal entities to build, operate, and maintain the network.
Exactly, Your Honor. And the network is the network that has been defined on the 700 megahertz D block spectrum.
Where's the network limited to the 700 megahertz?
If you look at the license that is allowed to be granted, which is under 1421, A, the commission shall reallocate a license to the First Responder Network Authority, quote, for the use of the 700 megahertz D block spectrum and existing public safety broadband spectrum. And before Your Honor thinks that existing public safety broadband spectrum is something broader than the 700 megahertz spectrum, Your Honor should refer back to section 1401, which defines existing public safety broadband spectrum with reference to specific frequencies from 763 megahertz to 768 megahertz and so on. So Congress was quite specific here, both about what it wanted FirstNet to be. And it seems sort of inconceivable that Congress would have gone so far as to legislate things like the daily per diem for FirstNet's board members and not mention that FirstNet would have access to potentially 50 megahertz of additional spectrum, a fact that would have been extremely important for those who were bidding on the RFP for the 20 megahertz of spectrum to know at the time.
So the broad contracting authority, which is mentioned twice in the statute, cannot include contracting outside of the 700 megahertz band. That's the position.
That
your
what
point.
FirstNet is limited to in this is the 700 megahertz D block spectrum, and that Congress was
so this
extremely
broad
clear about that.
But also the broad contracting provision with federal, state, local organizations doesn't include outside the 700 band.
It is for operation of the National Public Safety Broadband Network, which is limited to the 700 megahertz D block spectrum. That is what the contracting authority is limited to, Your Honor. And importantly, the commission's, as I said, the commission's authority is likewise limited by the Spectrum Act. So it does just seem very odd that Congress would have so issued such detailed specifications and yet forgot to mention that actually FirstNet could get access to an additional 50 megahertz of spectrum worth $15 billion. If I could turn.
Your lead argument rests on an inference from a regulatory structure under which the FCC allocates spectrum to non-federal entities and manages those entities, and NTIA allocates spectrum to federal entities and manages those entities. If that's true, why did Congress require the FCC to grant the initial license to FirstNet?
Because this was a one-time carve-out from the ordinary default principle, and that's why, in fact, you needed legislation to do this. This was spectrum that was being used. The 700 megahertz D block spectrum was spectrum that was being used under the auspices of the FCC by state and public local subdivisions.
They already
So they had to reallocate the spectrum
in that band.
Yes, there were already
Non-federal entities.
there were already non-federal entities in that band who had to be relocated and the spectrum had to be reallocated. So that's why the Congress ordered the commission to do that with respect to this single license. And that's why what the commission had to do here, initially FirstNet and PSSA urged the commission to just grant FirstNet a license directly. Once Cersei and others pointed out that that would be unlawful, they pivoted to this whole workaround situation, which circumvents the important limitations that Congress placed on their authority.
Does NTIA in fact regulate federal licensees the way the FCC regulates non-federal licensees? It's an aspect of the case that's very puzzling to me. I would think that agency should be front and center in this dispute, and they are oddly silent.
NTIA assigns spectrum to federal agencies. I am not as familiar with exactly how NTIA, other than what the FirstNet entity does here, what NTIA does with respect to how it oversees other federal entities' use of spectrum. But here, the authority that we are challenging is the commission's authority and FirstNet's authority. If I could turn to just the workaround and why each of the aspects of it are independently contrary to law.
Yeah, I mean, I'll just for your benefit, I'll tell you that argument has a lot more intuitive force, at least in my mind, if NTIA is this independent regulator that is and should be handling federal entities like FirstNet.
Well, it is. I mean,
As opposed to just, some formal thing that makes the initial assignment of spectrum and then FCC is effectively regulating everything.
right. I mean, what's happening here is FirstNet knows that it should have needed to go to Congress to ask for more spectrum. And instead, FirstNet went to the commission to ask for more
Why
spectrum.
couldn't they go to NTIA? The statute says NTIA assigns spectrum to federal entities. It would seem like that's what should have happened.
Well, what did happen is that they went to the commission and the commission established this whole workaround. So the commission used the 309J exemption.
Do you agree that they could have gone to NTIA?
They could have, I assume that they could have lobbied NTIA as well, but I think NTIA realizes that Congress needed to allocate additional
Could
spectrum.
NTIA at this point just bless this and say, yes, we agree with what the FCC is doing to the extent we are responsible for assigning the spectrum of FirstNet. We authorize spectrum to operate in this other band.
No, because
Why
this
not?
is state and local this is spectrum where there are incumbent state and local public safety entities that the commission oversees. So this is spectrum where NTIA doesn't have authority over this spectrum. The commission has authority over this spectrum. It's taking spectrum that is being used by state and public local
And the
state.
statutes are keyed to whether the broadcaster is a federal entity or not.
I'm sorry, Your Honor.
The statutes, as I understand it, the FCC assigns spectrum to non-federal entities.
Right.
And TIA to federal entities.
Right.
So it doesn't, you said what matters is who is already operating in that other band.
Right.
Seems to me what matters in terms of who the regulator is the entity federal or not?
So that, and the entities in this band are not federal. Right now, the existing incumbents in the band are state and local public safety entities, and it is a spectrum that the
We're sort of going
commission
around
has
in circles.
regulatory
I mean,
authority
in your view, the workaround is to enable NTIA, is to enable FirstNet to operate in the other band.
Yes,
FirstNet is a federal entity.
yes.
They're the government agency that tells them what bands they can or can't operate in is NTIA.
Yes. So what the problem here is that the commission is circumventing the limitations on its authority, and it's doing so with a workaround that is, both steps are independently contrary to law because the band manager does not qualify for the public safety services exemption under Rule 309J. And then there is also the problems with the sharing agreement under Rule 2.103B because there is no actual consent being provided by the state and local public safety entities.
Well, but the order specifically reserves that any sharing agreement that occurs in the future has to be compliant with the regulation. Isn't that right?
It does. And that's why we think it's
So
also
you're
sort of
perhaps
arbitrary that the
projecting that
commission.
it might not comply, but the commission specifically says that for there to be a sharing agreement, it has to comply with the regulatory requirements.
Right. And that's where we see the commission is really trying to have things both ways. On the one hand is trying to claim the public safety services exemption by saying, well, of course, FirstNet's going to be there and FirstNet provides public safety services. On the other hand, they're trying to say, oh, actually, we're kind of being tentative about whether this sharing agreement is actually going to happen or not. So that is sort of an additional reason why the commission's decision is arbitrary and capricious. If I could touch briefly on just the reliance interests at stake
Can I
here.
just ask you one other statutory question? I mean, Section 1422, which defines the public safety broadband network, doesn't make any mention of the 700 megahertz. What do you make of that?
Section 1422 says
Which is what
that,
actually defines the network, right? That the network it has to ensure the establishment of a nationwide interoperable public safety network. And then it talks about all the network components, none of which are limited to the band.
Right, but I think Your Honor has to read that provision in concert with all of the other provisions, 1401 that defines the actual spectrum at issue, 1411 that says reallocate the 700 megahertz D block spectrum, 1421
Right,
that
but
says.
but the network itself, you're saying, is limited to that band. So, I mean, one way to read the statute is Congress creates a network and it assigns it a license. But does that mean it's exclusive to other like that it could never, like through contract or some other agreement, operate outside that band? I think that's the difficulty.
So what is happening here, though, is Congress sort of reallocated 20 megahertz from state and local public safety entities in this statute. What the commission is doing now with no other statutory authorization is saying, here you go, FirstNet, here's another 50 megahertz of spectrum on an entirely different band. It's worth $15 billion. This is something that would have been, as I mentioned earlier, very helpful for people who were bidding on the initial contract for the FirstNet authority to know that it was not just 20 megahertz of spectrum that was going to be at issue, but an additional 50 megahertz and potentially even more under the commission's reasoning. It could allow FirstNet to take over any other bands.
Isn't the 50 megahertz, though, what you're defining, though? I mean, not all of that is available for FirstNet to use, right? It's just
So
the
what
parts that are, in the, like the unassigned parts or the unused parts of the spectrum.
So what the commission's order actually says at paragraph 24 is that the band manager will be, and I'm quoting here, the band manager will be authorized to enable FirstNet to operate anywhere within the geographic area of the overlay license. And then when an incumbent licensee cancels or terminates its license, or its license is canceled or terminated for lack of use or something, it is that the spectrum then becomes available for
Not
sharing to
all of
FirstNet.
it, but whatever is unused or is later canceled or terminated.
Right. And that's sort of the independent problems that we have raised about the fact that the whole point of the order is in fact also requiring this license substitution process where incumbents have to forfeit their broad geographic licenses that they have been relying on for years and making investments in the idea that they can expand over time for these narrower site-based licenses. The effect of that is essentially to make additional unassigned spectrum available for sharing with FirstNet. And I would encourage the court, for example, to look at the comments that BART submitted below or the declaration that BART submitted in support of their stay application to show that, for example, these entities made billion-dollar investments in reliance on the idea that they could, in fact, expand over time. And what the commission says about that is it's really striking, actually, is paragraph 54 of their order. There's a single line, basically, where they dismiss the reliance interests by saying, we know people might have relied on their licenses to expand over time, but they tie it only to the fact that the licenses are currently frozen. And then they say, in fact, you can seek a waiver if you need, which means that entities like BART that used to be able to move base stations, add new base stations without commission approval, now have to go back to the commission to fulfill their duties.
There's, I think, some hard questions on legal authority and maybe some hard questions on reliance. But on the other hand, it seems like the commission had a very real problem here it was responding to and just on an intuitive level responded in a very reasonable way. You have this band that's structured in a way that has proven to be suboptimal. It's underutilized. There's a public safety concern. And what do? They look to an entity that has built up this other public safety band with Congress's blessing and seems to be working pretty well. So, why is it arbitrary to just replicate in the second band what FirstNet built up in the first one?
So I think a couple of responses to that, Your Honor. First, I think that is the commission's main argument here is sort of defer to our kind of judgment about spectrum efficiency and how to manage spectrum. But this isn't about sort of deference to technical expertise. This is about statutory authority. And what's very clear from the Spectrum Act. and the
I'm on our.
communications- And as to whether it's arbitrary and capricious, what was arbitrary and capricious was dismissing the reliance interests of incumbents without saying more than literally a sentence about it. And I point the court to, as I said, paragraph 54 of the commission's order, where all they say, there's no sort of Encino Motor Cars weighing of reliance interests or anything like that. There's simply we think that actually this will give us a stable landscape to be able to assess current usage. And if you're really worried about something, you can get a waiver. But of course, a waiver does not solve an irrational rule. We also think, Your Honor, as to what was arbitrary is the commission ignored a lot of the problems with FirstNet, the 20 OIG reports about FirstNet's lack of oversight of AT&T, the fact that FirstNet is sunsetting, the fact that FirstNet on the 700 megahertz currently only uses a fraction of that spectrum for public safety. And in fact, most of it is used for AT&T for its commercial subscribers.
Doesn't the substantial underutilization at least suggest that there might be structural problems in the way they've handled this market, and the licensees have to deal with all of this potential interference, and that seems to be keeping licensees away from bidding? And so, like, you have the licenses, but they're not working out all that great for anyone.
So a couple of responses to that, Your Honor. First, what's kind of interesting is that while the commission talks a lot about underutilization, in fact, what the commission did in this order is for the first time require the granular licensing data from incumbents to be able to tell whether there actually is in fact underutilization. But even assuming that there is underutilization, the way to solve it is not by sort of taking away the broad flexibility that incumbents had to build their systems over time, but is not to kind of contravene statutory restrictions on their authority. We have, in the last order, the commission did adopt sort of a band manager for purposes of frequency coordination, et cetera. We did not challenge the idea that a band manager could come in and help with frequency coordination. What we do challenge is the band manager getting a nationwide overlay license and serving as a pass-through of spectrum to FirstNet and its commercial partner, AT&T, giving them a windfall that distorts the competitive marketplace as well.
I just have could FirstNet, in your view, contract with incumbents separately on an individual basis to share spectrum or to help them utilize spectrum or something like that?
So under 2.103B, which is the sharing arrangement, an incumbent could, if it wanted to, it could reach a shared use agreement with FirstNet. However, what's happening here is that this is being sort of foisted upon incumbents with a band manager providing consent in place of the incumbents, which is not at all what that regulation is meant to provide.
Does the band manager's authority, though, cover licenses that are held by incumbents? Doesn't it just operate in the spaces where there are not incumbents operating?
The band manager operates what is called a nationwide overlay license. So it will sit on top of the incumbents, and is also told to work with incumbents to, quote, rationalize their use of spectrum. So the band manager, it appears this order contemplates, will have some authority over incumbents.
For spectrum that is used by being held by an incumbent, the band manager couldn't force them to share with FirstNet, could they?
They could not.
Like their full licensing authority only occurs in the interstitial spaces where there isn't an incumbent. At least that's how I understood this.
And those interstitial spaces are also being kind of multiplied by the commission's order.
Yes. Right.
Yes. So the band manager is
the
then
interstitial
essentially
spaces are expanding because of the way they are shrinking the incumbent licenses. But they couldn't force the incumbents to share. The band manager couldn't force the incumbents to share what is actually within their license.
I think that's right, Your Honor. But sort of what I'm trying to get at is that in the current status quo, they do have spectrum that the band manager will be forcing them to share because they are going to forfeit their geographic license for these narrower, smaller site-based licenses that the band manager will then get access to spectrum.
So the FCC is creating more spectrum that the band manager can then use to share with FirstNet. And that's,
Yes.
so your objections are in some ways like all
Interconnected.
Yes.
Yes, Your Honor.
The regulation seems like a very odd fit for what's going on here. If you imagine the non-workaround situation, which is a federal entity wants to use public safety bands with non-federal entities. This band is structured so that how many licensees are there within this 4.9?
There are currently about
Hundreds.
3,500 state and local
Yeah,
public safety
so-
entities, many of which hold statewide or countywide
And
licenses.
prong 2 says the federal entity has to get consent from the licensees involved.
Right.
Unanimous consent from 3,500 licensees. Just
No, but
the reg just doesn't seem to fit.
so what the rule contemplates is, to Judge Rao's point earlier, right now, if an incumbent actually wanted to share spectrum with FirstNet, it could do so under 2.103B, where there actually was sort of mutual agreement. What's happening is
Right,
that
but
the
you've got
commission
this-
is using this.
You've got this weird public safety specific scheme where you don't have individual licensees on defined spectra. You have 3,500 of them allowed to operate anywhere in the band.
Well, they hold licenses for their geographic areas. So for
Right.
example, a sheriff would hold a license for their legal jurisdiction, or
Right,
BART
right.
holds a license for its 5 counties. And so what is happening here is the commission is relying on this sharing arrangement regulation to basically have the band manager, who is not a state or local licensee, provide consent to share with FirstNet. So I think Your Honor is correct that it is a very odd fit for what is actually happening here. And that may be why the commission sort of punts on whether 2.103B would actually be satisfied by this arrangement, although that is, again, kind of arbitrary because the commission is elsewhere relying on the fact that FirstNet is going to be in the band and providing services.
All right, thank you. We'll
Thank
give you some time on rebuttal. Overfold.
Morning, Your Honor. Excuse me. May it please the court, Leif Overwald on behalf of the Public Safety Spectrum Alliance and the Public Safety Broadband Technology Association. PSSA and PSBTA come at this case from a diametrically opposed perspective from the CERC petitioners. The FCC did have the authority to issue an overlay license to the 4.9 gigahertz bands to the band manager and authorize the band manager to enter into a sharing agreement with FirstNet. And its decision to do so was amply justified by the commission's recognition for over a decade that the 4.9 gigahertz band has been grossly underutilized. One study in the record estimates that more than 90% of this important public safety resource has not been used during the time that the commission has set it up for that use.
So can we talk about standing for PSSA petitioners? Not sure that the standing theory is entirely apparent in your opening brief. And even with the additional material in the reply brief, I guess I'm wondering, where's the redressability? So the primary claim of PSSA is that the commission should have gone further. But you're not bringing like a agency action unlawfully withheld claim or something like that, which you really couldn't do because they're not required to do anything in this space. So where's the redressability?
Well, so under
Explain the theory of redressability for
course,
wanting
Your
an
Honor.
agency to do more?
So under the APA, the FCC has to explain the lines it drew. And the entire thrust of the order is that making the spectrum potentially available to FirstNet through a sharing agreement is the best way to robustly ensure deployment on this long underutilized resource. the lines that the agency drew in the rule. It does not explain. For one of our comments, one of the reasons this band has been underutilized for quite a while is these non-exclusive, overlapping, uncoordinated geographic licenses. The FCC acknowledged that we made that comment. It didn't offer any substantive response at all. If the court sends that back for the FCC to consider that question, it could very well agree with us that these geographic licenses are part of what's contributing to underutilization.
You
of
want
the band.
remand without vacater.
Yeah, I mean, we are being injured by this order not being taken, not being given a full effect as quickly as possible. So we would ask for remand without vacater because much of what the rule does do important work to sort of
You presumably
address.
don't want the rule vacated because you want the rule to go further.
Right. We want the underutilization of this ban to be addressed as quickly as possible. And I mean, in the FCC's brief, we're talking about 2 territories and 4 states, but no one thinks there's only unused spectrum in this band in 2 territories and parts of 4 states. There is a lot of white spaces. The entire thrust of the rule is that allowing FirstNet access to that spectrum, they can put it to productive use. They've already created this national network that at the time of the rule, over 6 million users were on. We're now almost 8 million.
Redressability is tough, though, where you want the agency to do something rather than not do something. So when a party comes and says, well, the agency didn't explain why it is doing something, then like a remand, I mean, the redressability seems a little more obvious than when a party is saying, we want the agency to do more. Things, and the do more is things that are within the FCC's discretion, not a statutory requirement.
I still think the court has to look at how the FCC explained the lines it drew and on sort of our other main objection, which is that rather than saying that once they've identified spectrum that's not being used by incumbent licensees, you should immediately allocate that to the overlay license. They reserve judgment. That does have concrete effects. People were reporting their granular data in July of this year. At that time, that unused spectrum could be immediately moved into the overlay license. Instead, the FCC, again, no one disputes that there is unused spectrum out there, but they reserve judgment on the policy determination about what they're going to do with that without any sort of a reason given in the order.
Well, their reason was sort of a, one step at a time sort of reason. It's taking things incrementally, which we have a number of cases saying is permissible.
But even when an agency is moving incrementally, no one disputes that is often a reasonable way to proceed. You have to give some reason why you're choosing to proceed beyond simply, I would prefer not to take the additional step. I mean, it's often reasonable. That does not mean it's categorically reasonable not to take a step. And when you look at this order, the entire thrust of the order, again, is that moving this unused spectrum to use not in this sort of balkanized system of overlapping geographic licenses, but making it available to FirstNet, which has already built out a nationwide broadband spectrum for use by public safety users. That's the entire sort of thrust of the rule, and they don't offer any explanation for why you would confine
Their
that.
explanation was we need data. And that's part of what the order provided, was this system of collection of data so that could be evaluated and they could, then regulate further once they get the data.
Well, so there are 2 questions, and the FCC indicated they needed data for one, and that's the question of where is the areas of unused spectrum that could be put to more productive use if you enter into a sharing agreement with FirstNet. The question we think they should have decided in this order is, once you've identified that spectrum, should you make it available to the overlay license? You don't need any data to make that policy determination, and they didn't identify any reason why you would not. Again, given we agree with the vast majority of what the FCC is doing here, but when the entire thrust of the rule is that putting this unused spectrum to use by FirstNet will allow many more public safety users to make productive use of this important public resource, they have to do more to explain why you would just limit the effect of that rule to the handful of unassigned.
What case do you have that says that if the agency identifies a problem, it has to solve the whole problem rather than dealing with solving it incrementally?
We acknowledge agencies can proceed incrementally. It's often reasonable to do that. again, it's a question of providing some reasonable explanation for why you are not taking an additional step. And in this order, I mean, it's just the apparent value of extending it.
Precedent says you don't have to, solve the whole problem all at once. You can proceed incrementally. Why do they even have to say that? We all know that.
Well, again, this is the point. It's often reasonable to proceed incrementally, but that does not mean it's categorically reasonable. And we're talking about an important spectrum that has been dedicated for public safety use for over 2 decades. The FCC has been recognizing since 2012 that the spectrum is not being put to use the use it hoped it would be when it initially set this aside in 2002. And it also recognizes, I mean, this is important broadband services that first responders can use to provide life-saving services. The FCC should do something more than just say that it would prefer not to take that additional step now.
All right, thank you. Time, we'll give you some on rebuttal.
Thank you.
Morning, Mr. Kandu.
Good morning, Judge Wilkins. May it please the court, Adam Kandu for respondents. This case goes to the heart of commission authority, its statutory duty to license our nation's spectrum and ensure efficient and effective use of that spectrum. In the order on the review, the commission used this authority to make an important but incremental step to solve a problem it has faced for nearly a decade and a half, the persistent underutilization of the 4.9 band. And the commission does 3 things in this challenged order. It assigns the band manager, when it is selected, a license for spectrum, which is now unassigned. It authorizes the band manager to initiate a sharing agreement for this licensed spectrum. And last, the commission recognizes that FirstNet entering into this agreement will increase band utilization, enhance public safety coordination, and encourage advanced technological deployment.
The whole point of this order is to enable FirstNet to use this other band of spectrum, correct?
It's not simply to allow FirstNet to use the unassigned parts of the spectrum.
It is at least.
It is certainly at least, but it should be remembered that the band manager is playing important coordination functions that respond to the problems that have been facing the band for a decade and a half, which is we have a bunch of unlicensed users who can't coordinate, who are constantly having interference connection problems, and we don't have one centralized authority who can coordinate this and resolve disputes. And with that authority,
the band manager has some regulatory like command and control responsibilities. But again, the main point of this order is to allow FirstNet to use spectrum. And with regard to that, the band manager, it's this very weird arrangement where they are the licensee, but they are specifically not allowed to use spectrum. So the only point of this is to create a non-federal entity to bring this within FCC jurisdiction to license a federal entity to use a different band of spectrum.
Well, it should be remembered that FirstNet is not the licensee. It shares spectrum with the licensee, who's the band manager. And as for being,
could FirstNet have just come to the FCC and asked for an overlay license in the 4.9 gigahertz band?
Well, that question isn't present in that's not the way the commission
rules. Very curious to get your answer.
It goes to a difficult question of FCC authority. Certainly, Section 305 would present serious legal questions as to whether or not but here we're sharing, and it's not an unusual or freakish arrangement. Sharing with federal entities for public safety, as the order cited in the brief says, goes back to 1998, over 2 decades. And it's because it allows for coordination of public safety and law enforcement, and it allows for more granular sharing that doesn't require a meeting of the FCC and NTIA.
It makes a lot of sense, but there's a an antecedent legal question about which federal agency has to authorize and gets to oversee the arrangement. And the statutory scheme just seems keyed to whether the licensee is or is not a federal entity.
Correct. But again, the sharing has existed in other places. We've had federal sharing of state and license and FCC license spectrum in many situations. It's not that unusual. Furthermore, as far as oversight, this is a cooperation between NTIA and the FCC. Remember that FirstNet is a subsidiary of NTIA. NTIA picks its board and runs its management. So it's, and we have consulted with.
Does NTIA oversee FirstNet in the way that the FCC oversees its non-federal licensees? I mean, you allocate the spectrum on the front end, but then you have all sorts of ongoing oversight issues. So who does that? For federal, just for FirstNet in the 7,000 band?
Right.
Who does that?
Well, FirstNet is a
NTIA.
Yeah, NTIA does correctly. And so NTIA is regulating this. Again, they were aware of this agreement. They acquiesced to it.
So your position is that at no point in this process will NTIA have to separately license or sign off or approve in any formal way when you A, identify the band manager, and B, approve the contemplated sharing agreement.
I think
your position is FCC is going to do all of that. NTIA is not.
Well, I think FirstNet, NTIA through its oversight of FirstNet would certainly be involved in all those decisions. And also I would remind the court that the tradition of the relationships between NTIA and FCC in the spectrum allocation has always been an informal relationship. It has been one in which we sort of agree what makes sense and go forward, and it has worked fairly well for a long time.
What statute or regulation can you point me to that says that NTIA will be involved?
I would point generally to the organic statute that creates FirstNet, which places it under NTIA authority. NTIA is involved with the appointment of all of its board members. It has oversight authority. It looks at what it's doing and to ensure that it's maintaining its.
What does any of that have to do with involvement with the FCC's decision of selecting the band manager, et cetera?
Well, under the system, the band manager will be done through the FCC. So the short answer is that NTIA and the FCC and the NTIA and FirstNet will not be intimately involved with that decision.
So the closest thing I found to address Judge Wilkins' question on NTIA involvement is a statement buried in footnote 159 of your order in which you report that NTIA is fine with just letting FCC do all this.
Right. As I said, NTIA did acquiesce to this situation, and it was on an informal basis. That's the way we've been doing business, and due to the difficulties and subtleties of some of the negotiation, it has worked fairly well.
And you think that satisfies the statutory scheme, which says NTIA has to allocate spectrum to FirstNet?
Correct, and that these sharing systems and agreements have been around for decades, and they seem to work.
Seem to work and being legal are two different things, though, aren't they?
Well, they seem to further advance an efficient use of the spectrum. I think that, in general, the basic questions about spectrum allocation, what is federal, what is licensed, is worked out through an informal agreements between the FCC and NTIA.
Which are both part of the executive branch after all.
I'm sorry, ma'am?
Which are both
Your
part
Honor?
of the executive branch
Yes,
after all.
yes, that's right. This is the way that the system has worked, and it has, I think the record is good as far as moving the system to a more efficient use.
Can I ask you a question about how we interpret this order? It seems that FCC in its brief is suggesting that the unassigned spectrum that the band manager shares with FirstNet is only the spectrum that was never assigned. I guess like either the part or whole of those 6 states and territories, something like that.
Yes, Your Honor.
But doesn't the order free up additional spectrum by kind of making the incumbent licenses, I guess, smaller in a way? So like there's spectrum that's freed up from the relicensing.
Right.
And so isn't that now part of the unassigned spectrum that is going to be part of the overlay license? I mean, it seems that has to be right. Like if those licenses are in fact reducing spectrum use by incumbents, now that spectrum is unassigned and would go to the overlay license. Is that right?
Respectfully, no.
Okay.
And I would refer the court to paragraph 59 of the order, where we make clear that unused spectrum.
Not unused,
I'm sorry.
unassigned spectrum,
Okay,
which is
okay.
different, right?
That's right. But it does come to your question. So there's only a few areas of unassigned spectrum that nobody has a license at the time the order was written to use. And those are the areas in the 4 states and 2 territories. And then there is what we call the unused portion. So what the order did is said, look, incumbents, one of the primary purposes of this order is to respect your current operations. We don't want to interfere with what you're doing at all. But you have to freeze, because one of the problems why we need to do all this data collection is because we have no visibility into what's going on in the spectrum. So for instance, let's say there's a state trooper's office who has license for the entire state. They could be using it for one temporary point-to-point communication, just one little strip of territory in the entire state, and the rest of it's fallow. And right now, the commission doesn't know that. It can't tell that. So what it said is, look, freeze, and the areas that you're not using will be considered unused. And you can't build into that area until the freeze is over, until we collect information. We know what we're doing. And then you may get it back, or the commission might decide that it should be repurposed.
So the relicensing doesn't create any unassigned spectrum. It only creates unused.
That's
spectrum?
right. It is, this is not a technical term, but it's kind of in a limbo. And what we're saying is the commission has to look at this, but it has not reassigned that. It doesn't have anyone, no one else.
And the new licenses don't make any of that spectrum unassigned?
No, they don't make it unassigned. The band manager right now is limited to those few areas, and it would take some type of further commission action to make those unused into unassigned. And at that point, I know I'm not supposed to concede anything, but at that point, that's when CERC could come in and say, look, you've done something to our licenses. But right now, this is sort of in a limbo, it's in a freeze, and we have to collect information because we just don't know what's going on.
Seems pretty unlikely, though, given the thrust of this order, that this might be headed towards, oh, never mind, we'll just let the licensees go on as before.
Well, yes. I mean, in the sense that, I would certainly agree that it will be different. But again, the whole purpose of the data collection is to find out what's going on. And I couldn't say. It is certainly possible that everything will go on before. It could also be that there's a huge amount of unused spectrum that commission finds could be used more effectively.
Can I ask you a question about the contrary to law arguments that the CERC petitioners make? So they say FirstNet can't operate outside of the license area that was specifically conferred by Congress, and that's the best way to read the Spectrum Act. And in response, the FCC just points to a lot of general authorities that it has, which frankly, I never find all that persuasive. It's like, oh, we can do anything we want in the public interest. So obviously we can do this. But I guess I'm wondering why the FCC doesn't rely on the specific contracting authority in the Spectrum Act. Is there something about that contracting authority that FirstNet has that doesn't make it a basis for the sharing agreements? Like, is there something, because to me, just the plain meaning of FirstNet has legal authority to enter into contracts with a whole range of public and private entities suggests that it would have authority to enter into a sharing agreement with the band manager. But maybe there's some reason why that isn't, I'm misunderstanding what that statutory authority means.
No,
The FCC doesn't rely on those provisions. And so I just want to understand if there's some reason why I'm misreading
right.
Spectrum.
Well, I mean, it could be we just haven't thought it out, and we haven't. But I think our point would be that the band manager is the licensee. So the band manager has a sharing agreement with FirstNet.
The sharing agreement is a contract.
That's right. It is sharing. It is a contract, but we're not regulating FirstNet directly. So you're right. FirstNet's authority to enter into the agreement with the band manager would be governed by that. Yes. And
One of the arguments the Cersei petitioners makes is that FirstNet has no legal authority to do this, and that it's outside the Spectrum Act, which is different from saying the FCC lacks authority under the Communications Act.
That's right. I think it's just really a matter of the commission believes there's specific regulatory authority, namely that found in 2.103 that directly addresses the situation, and that should be.
But that regulation wouldn't answer the question whether, like, if FirstNet lacked statutory authority to do that, it couldn't gain that authority from regulation.
But yeah, no, I agree. I mean, I think that's
so there's no reason to think that the contracting authority wouldn't cover something.
No, absolutely not.
Okay. Thank you.
All right, if you have any final points you'd like to make, you can make those.
I would just respectfully ask that the court dismiss the petition on review. Thank you very much.
Thank you. Mr. Turner.
Good morning, Your Honors. Joshua Turner, may it please the court, Joshua Turner on behalf of the Fraternal Order of Police. FOP represents more than 370,000 officers across the country in communities both small and large, and they understand how important public safety communication, especially broadband public safety communication is. That's why we're here today enthusiastically supporting the FCC's order, because as Judge Katsas, you mentioned, this has been an ongoing problem in terms of utilization of the 4.9 gigahertz band. That band is currently 90% unoccupied, according to the record. The FCC is collecting some granular data about exactly where that lack of occupation is, but the record shows that for years, this band has not lived up to its promise. In contrast to FirstNet. FirstNet has worked exactly as Congress intended. FirstNet has created a nationwide public safety broadband network that FOP members and other public safety professionals are using every day.
What does the record show one way or the other about whether that FirstNet band, the 7,000, it does or does not suffice to enable your
Yes, Your Honor.
super important communications?
The 700 megahertz band was set aside by Congress for the initial purpose of this public safety broadband network. The record shows FirstNet, I believe in 2013, filed comments in the record saying, you know, we could make use of the 4.9 gigahertz band. We could use that to provide broadband services. And as we get more built out and as we push into other and newer areas, we will have the need for this additional spectrum to provide 5G and other broadband services. So that is in the record. One of the things that Your Honors have focused on, which I think is very important, is this question of the band manager and authority. You know, my counsel for Cersei says this is just a workaround, right? This is just the FCC trying to do something that it doesn't have the authority to do. But that's not actually what's going on here, right? The band manager has a number of different roles that it plays, one of which is coordinating the spectrum use between incumbents. Another, the FCC has added in the order under review, is to coordinate spectrum use with FirstNet and to coordinate this national overlay license so that FirstNet can use it. Now, the question of where FirstNet gets the authority to do that is, of course, a good one. That comes from Section 305 of the Communications Act, which delegates to the president the ability to decide how federal agencies and other federal users use the spectrum.
And then later subdelegated
to NTIA.
NTIA.
Yes. But the president ultimately is the one who has to control federal use of the spectrum. That's the sort of setup that the bilateral setup that is set up by the Communications Act. Broad authority for the FCC to determine what should be done with non-federal uses, and the federal government the federal use is controlled by the president. And that's what's going to happen here. FirstNet's authority to operate in this spectrum will ultimately be at the discretion of the president. If NTIA or the president decides that FirstNet should not use this spectrum, FirstNet will not be allowed to use this spectrum. This is not the same as if FirstNet were being granted a license by the FCC. That's the critical legal distinction here, and it's one that I think answers, I hope, the court's questions.
Well, but I thought the FCC's position is that determination by the president or NTIA is unnecessary. All we need to do is think of this as the FCC licensing the non-federal entity, which then contracts with someone.
I don't think that that's I obviously can't speak for the FCC. I don't think that that's the FCC's position, and I don't think that's how this will work in practice. What the FCC has done is exercise its broad general authority.
And I'd feel much better about this if there's some point down the road at which we know that NTIA will formally review this and sign off or not.
Well, the memorandum of understanding between the FCC and NTIA contemplates exactly the kind of spectrum sharing arrangements and exactly the kind of collaborative effort that the FCC is engaging in here. But ultimately, Your Honor, the question of whether or not the federal government authorizes FirstNet to use this spectrum is one for the president to make. And Your Honor is exactly right. I mean, there may come a point where the president, for whatever reason, decides that NTIA is not going to authorize this and that FirstNet is not going to move forward with the band manager arrangement. They aren't going to enter into the contract with the band manager to share this spectrum. That is something that is certainly the president's prerogative. And the FCC is not claiming, at least as I understand the order, that it has authorized FirstNet to operate in this spectrum absent presidential authority.
I mean, even if you assume a unitary executive, including the FCC, 100% accountable to the president, Congress can still assign a decision to one agency or another, to state rather than treasury, both of whom answer to the president. And if they assign it to state, it's state that has to make the decision.
Certainly, Your Honor.
Without presidential direction.
No, absolutely, Your Honor. And to be clear, I'm not making an argument based on unitary executive in one way or another, because I think what's happening here is that the way that the Communications Act has apportioned responsibility is being respected. The FCC is taking the action that it needs to take to make this spectrum available for use by the federal government, right, in a shared basis. And that's something that the commission has done, going back decades, right? The Bendix case we cite in our briefs goes back to 1960, where the commission makes non-federal spectrum available for federal use. So that's what the commission is doing here. That's the commission's role. NTIA's role and FirstNet's role is to come in and operate in that band pursuant to the FCC making the band available for that kind of sharing. But they're doing it under their organic authority. They're doing it under the authority granted by Section 305 and by the Spectrum Act. And Judge Rao, I think you were exactly right.
Which require assignment of that spectrum to FirstNet by NTIA.
The Spectrum Act requires assignment
No,
of,
just 305.
oh, sorry.
Forget about this.
So section 305 says that the president has the discretion to assign frequency use by federal agencies. Yes,
And not FCC.
not FCC.
Right.
But FCC has the ability to make what is otherwise non-federal spectrum available for federal use, as long as that use is under the auspices of the president under section 305, which is what's happening here. So the FCC can say any non-federal spectrum that the FCC has control over, the FCC can say, we're going to make this available for federal use too. We're not directing the federal government to use this spectrum. We're not requiring them to do it. We don't have the authority to do that. We're making the spectrum available for federal use should the president decide that he wants to use that spectrum for whatever purposes he wants to use it. Now,
What in the order requires presidential action or finding before that is implemented?
well, the order contemplates that there will be the band manager, and the band manager will enter into a sharing agreement with FirstNet, and that won't take effect until FirstNet and the band manager reach this spectrum court, the sharing agreement. So that's the sort of point at which the executive, in the guise of NTIA and FirstNet, have agreed to use the spectrum that have been made available to them by the FCC in the guise of this band manager. So that's the point, Your Honor, where there's sort of federal action, presidential action. And I don't think there's anything, I don't think there's anything that requires any particular mechanism by which the president decides to utilize or assign spectrum. Certainly section 305 doesn't. Section 305 just says it's up to the president to decide how to do it. I don't think that the commission has to say we need a presidential finding before we make this available. I don't think there's anything in the law that requires that. Certainly, section 1422 does not. Nothing in the Spectrum Act does. And so just to point back to a question that Judge Rao asked, you asked, I think very correctly, is there authority under 1422 for FirstNet to use spectrum pursuant to agreement with license holders? And I think I heard counsel for Cersei say yes, that under 14, that the Spectrum Act allows FirstNet to contract with state and federal license holders in order to use their spectrum pursuant to 2.103.
With their consent.
With their consent. But if that's true, if the Spectrum Act does allow FirstNet to use that spectrum, that answers the authority question, doesn't it?
Means it can operate outside the 700 band.
We would think that that would be a fatal concession by the other side.
So sorry, can you tell me if this is unfair, but can you give me a yes, no answer to this question?
I will try. Before
FirstNet can operate in this new band, will there have to be further government action by NTIA or the president to authorize some further action?
I don't know the answer to that question, Your Honor, and I apologize for not knowing the answer to that question. Certainly, FirstNet, pursuant to its own internal processes, and as counsel for FCC pointed out, FirstNet is itself an independent agency within NTIA. So FirstNet is, in some sense, NTIA itself. Certainly, FirstNet will have to enter into a legally binding contract with the band manager in order to share the spectrum.
It seems like if you can't answer that question, yes, well, that takes a lot of the force out of your argument that the FCC is just cleaning things up on its end, but there's a whole different set of regulatory authorizations that have to happen on the FirstNet end.
Well, and what that might point to is a ripeness problem, right?
Maybe.
If where we end up is the commission has done all of its work, it's done everything it needs to do, everything within its authority to make the spectrum available. And there's a question now of whether NTIA has the authority that it needs to, or has exercised the authority that it needs to exercise in order to make good on that promise. Then maybe that's a problem. But that's for down the road. That's not for today, because the commission doesn't have control over that part of the process at all. And so all the commission can do is say, look, we've heard from FirstNet. FirstNet came in and filed something in the record saying that we'd love to have this spectrum. We'd love to make use of it. We've looked at the FCC, at the authority. We've looked at the Spectrum Act. We're confident that FirstNet can make use of this spectrum if we make it available to them. And so it's very reasonable for us to say, we're going to adopt an order that prepares the ground for that kind of sharing agreement. And, you know, ultimately, if it turns out that doesn't work for whatever reason, legally or otherwise, the commission may have to revisit it. But for today, the question is, was this a reasonable order? And the answer is certainly yes, because this is exactly the kind of creative problem solving that the commission was designed to address when it was given this sort of plenary authority over allocating the nation's spectrum.
Any other questions?
No, thank you.
All right, thank you.
Great, thank you.
Ms. Amundson, we'll give you 3 minutes for rebuttal.
Thank you, Your Honor. I'd like to briefly address a couple of questions that Judge Katsas asked counsel, and then also address Judge Rao's contract point. First, Judge Katsas asked counsel for the FCC, could FirstNet come to the commission and ask for a license to the 4.9 band? In fact, that is what FirstNet did. FirstNet did come to the commission and ask for a license to the 4.9 band. And once Cersei and others pointed out that that would be unlawful, that is when the commission and PSSA pivoted to what became the eventual sort of workaround of the band manager pass through of spectrum to FirstNet. Judge Katsas, you also asked what the record showed as to the use of the 700 megahertz spectrum for public safety and FirstNet's need to actually acquire additional spectrum on the 4.9 gigahertz spectrum. In fact, Cersei put in the record below that only a fraction of the 700 megahertz spectrum is currently used for public safety entities, and it is used primarily for AT&T to serve its commercial subscribers. AT&T certainly wanted access to an additional 50 megahertz of spectrum in the 4.9 gigahertz band, and therefore AT&T and FirstNet made comments before the commission suggesting the workaround proposal that the commission eventually adopted, such that while this goes to FirstNet, it is really changing the character of the band in that it will be available to AT&T for its commercial subscribers, while AT&T's competitors have to purchase spectrum at auction to serve public safety entities. So
question about the workaround. I mean, could FCC free up spectrum and just decide that it is for federal use and so therefore could be allocated by NTIA?
It is my understanding that the FCC can make spectrum available for federal use,
Right.
but
They can't license to a
large,
federal entity, but they could make it available for a federal entity.
right. So in the abstract, but what I think we need to do here is look very specifically at the situation we have here, which is the Spectrum Act, where we have Congress specifically talking about what it wanted FirstNet to do, where it wanted FirstNet to operate, what spectrum it was giving to FirstNet to operate on that spectrum, or to operate its network. And so, Judge Rao, I just wanted to address directly also your questions about the contracting authority, which, as counsel for the commission has conceded and no one raised. So that those were not arguments that the commission raised or that its supporting interveners or petitioner raised, that in fact it was the contracting authority that provides FirstNet with authority to operate.
When we interpret a statute, we can't not read provisions of the statute to determine the best meaning of the law. So I don't think that's
Fair enough.
They've defended that they've made the argument that it's consistent with the statute. So we can't not look at provisions of the statute because the commission failed to cite them.
So had they raised that, what we would have had the opportunity to address in our brief is the fact that that provision falls under 1426B1, which again talks about the single public safety wireless license granted under section 1421 of this title. And then section 1421 in turn, again, specifically refers to the 700 megahertz D block spectrum. We would ask the court to grant the petitions of Cersei, Bart, and the sheriffs. Thank you.
Thank you. All right, you are out of time. We'll give you 1 minute.
Thank you, Your Honor. Just on the need for the spectrum, the order makes clear that the more spectrum, especially of this sort of mid-band spectrum that's particularly good for advanced uses like 5G, the more that's made available to FirstNet, the better. And the fact that FirstNet can make use of that while rigorously prioritizing its public safety traffic is part of what made PSSA think it was such a natural candidate to make productive use of the spectrum. Counsel for the FCC noted unused spectrum is just being left in limbo as a result of this order. We respectfully think that that was unreasonable.
Thank you. Case is submitted.
This article, that's a very meaningful Monday, on their